participants. Can you check what one is your computer? Visa ಇಲ್ಲ ಹೌದಾ ಇಸ್ಕೊಂಡ್ಬಿಡ್ಬೇಕಾಯ್ತು ವಿಡ್ರಾ ಎಂದು ಬೇಡ ಇದೆ
It's so many mentions.
Welcome from vacation.
Which year? Which of this? 2026 interim order is granted. Now it has to be vacated. Stop this. Huh? We'll see. We'll see. Today, just now we started with the roster. Please copy. We'll see how we will take it.
The partition sold, my property, my elder brother party was the property. Trial court ordered for delivery of possession. In the meantime, he has taken a interim order.
We'll see. We'll see. Just wait for a week. We'll see. Let's streamline this. No, keep. After a week, we'll see.
Different in the original suit is the petitioner hearing. Order 6 Rule 17 application filed by the plaintiff came to be allowed. That is challenged on 5 grounds, my lord. The first ground is my lordship may kindly see
Suit
the
is of
application.
which year?
Suit is of 2023, my lord.
2023.
Yes, my lord. The response to the written statement filed by the defendant is what is the proposed amendment. My lordship may kindly see page number 46, my lord.
Page number?
46.
Why don't you come to the order? We'll first look at
Yes,
the
my lord,
order
yes, my
and then go back to that.
Annexure A is the order at page number 20, my lord.
Yes,
The reasoning at is page number 23.
yes.
The very small reasoning. My objections is not considered, my written arguments is not considered at all, my lord. Page number 23, my lord.
1 minute. Come to the amendment. Where is that?
Page number 46, my lord. 45 is the application. Annexure D, my lord. You may- If you may point out, my lord. If you may point out, my lord.
Yes. Yes.
Page 46, my lord. The proposed amendment para 8.
Yes.
A.
I've seen that. I've seen that.
Yes, my lord.
I've seen that.
It says it is actually it's submitted that after verification careful scrutiny of the document, it is learned that defendants are tracing their
As far
title
as
back to
para,
some.
as far as para 80 is concerned, they only
Yes, ma'am.
in detail have given the particulars about their source of title.
Yes, my lord. 8B also, my lord.
Yes. So how is it going
Tracing
to,
the title
how
as
is it going
narrated.
to cause any prejudice to you?
My lord,
8A and 8B.
This
So are the
is-
facts, they are not concocting, they are
This-
not, I mean, coming up with a new case. According to them, so and so is their document. What about the prior documents they have stated?
not prior document. It is about defendant's tracing of title, not plaintiff's tracing of title. This is about defendant's stating of title. What I have stated in my written statement, what I have traced my title, they are responding to it by way of amendment of plaint. Plaint
So
is
that,
amended
that
for
I found
responding
in
to the.
paragraph number 10.
Yes, my lord. Paragraph number 10 also.
Please come. Then counsel appearing for the petitioner
This
submits
is
that.
their title, my lord. This I am not agreeable about. I am only agreeable about para 8A and 8B.
Then counsel
So far
appearing for
as
the petitioner submits that. The plaintiff has filed the suit for declaration and injunction.
injunction, my lord.
After the written statement is filed, they filed an application seeking amendment of the plaint. In the said amendment, or what is sought to be introduced is about it is a kind of objections to the written statement. And by introducing altogether a new case, the trial court, by way of a very cryptic order, without any reasons, has allowed the application. considering this court, next para, this court, having heard the counsel for the petitioner peruse the order and also the IA that is filed seeking amendment. This court finds force in the argument of the learned counsel for the petitioner. Hence, there shall be stay of all further proceedings pursuant to the order dated so and so. The petition is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect by 17th of June, or else the stay granted by this court stands vacated. If the memo is filed, list this matter on 18th.
There are other grounds also, my lord. There are other grounds also that when relying upon its
That is
limitations.
okay, you
Yes,
got
ma'am.
to say that you can urge it at the time of when
Yes, ma'am.
other side comes. Not necessary that all grounds should be incorporated in your interim order. Yes.
Much order.
Tell number 2, M.E. Vedachala.
Petition
Yes.
has become infructuous. My lord. I'm filing a memo to withdraw
Take
with
that.
with liberty to file the necessary appeal.
Oh, final order is passed.
Please.
Against interlocutory order, you have filed this.
Please.
The memo is filed seeking to withdraw the petition. It is submitted that final orders are passed in FDP number 48 of 2002. And petitioner seeks liberty to file the appeal against the same, considering the fact that the final orders are passed. The writ petition has become infructuous. Accordingly, the writ petition is dismissed as infructuous, giving liberty to the petitioner to avail the appropriate remedy.
Tell number 3, Ramesh Kya.
My lord.
Yes.
Lord, arising out of the same order, my lord, several other writ petitions are filed. In those writ petitions, notices are ordered.
Take that order.
Please. Writ petition. Case number. Address is there. Notice is ordered, my lords.
This notice is ordered.
Please.
Notice to the respondents, petition is permitted to take out hand summons on the counsel appearing for the respondent before the court below.
Please.
List along with the WP number 37208 of 2025
Much.
and shall file a memo to that effect. Yes, please.
Tell number 4, A.R. Mohan.
Yes.
Lord, in this petition, I have questioned the legality of the order date 5/2/2026 passed by the trial court, whereby the trial court has passed an order giving police protection to the respondent number 1 in respect of the land, which the respondent number 1 is not in possession, and I am in actual physical
This is
possession.
suit for,
My lord, the respondent number 1 filed a suit for bare injunction. Even prior to that, my lord, I give a brief facts of the case.
That's what-
Just 2 minutes. My grandfather is the owner of the land measuring 1 acre 10 guntas in Saramba Tolbari of Sita Kampanhalli. He was in actual physical possession, and his name was mutated in the revenue records in respect of the cultivator's column. My grandfather died leaving 4 sons. Those 4 sons also died, leaving behind the petitioners as the legal representative, and they are in actual physical possession of this land. A person by name Munegowda fraudulently obtained a GPA from the petitioners.
from the,
Petitioners. A person by name Munegowda obtained a GPA from the petitioners fraudulently. Based on that
the
GPA,
registered GPA.
yes, ma'am. Based on that GPA, that Munegowda sold this land to the respondent number 1.
When is the date of sale?
Date of sale is my lord. Seven 10/2024.
7/10.
Date of sale is 7/10/2024,
Hmm.
and the GPA is dated 10/6/2024.
Hmm. Hmm.
After coming to know of these transactions, my lord, I have filed a comprehensive suit in OS number 75/2025 before the senior civil judge,
Hmm.
wherein I have questioned the legality of these sale transactions. I also filed application for grant of temporary injunction praying to restrain the respondent number 1 from alienating the suit schedule property.
Further alienating.
Yes. Interim order was granted.
When was the interim order?
Interim was granted. It is at 1/8/2025.
Hmm.
1/8/2025.
Hmm. Yes.
My lord, I had also filed another application for grant of temporary injunction. However, that came to be rejected.
Temporary
based-
injunction for, what is the relief?
Relief, restraining the respondent number 1 from interfering with my position.
Hmm.
That application came to be rejected.
Was it dismissed?
A common order was passed based on
Both.
yes.
Huh.
As against the rejection of my application, I had preferred a MFA,
Hmm.
and that came to be disposed of.
Saying,
To urge your contentions before the trial court only.
so that means the court has upheld the order.
After passing of this order, my lord, after passing of the orders on the applications filed by me, the respondent number 1 has filed another separate suit before the junior division, seeking only bare injunction.
Against you.
Yes, against me.
Hmm.
The court below passed a temporary injunction order. After several summons, I entered appearance, filed written statement. In the meanwhile, the respondent number 1 and her henchmen tried to dispose me from the social property.
No, this suit that is filed by the respondent number 1
Yes.
is subsequent to the dismissal of your MFA.
Yes. No, prior to that only. But after passing of the orders on IA number 2 and 3 in my suit, after passing of the orders on the applications filed by in my suit,
What is that suit number?
1075/2025 is the suit number.
Your suit is 75.
Yes, 75.
What is this suit? It's suit for injunction.
1076/2025.
Hmm.
This suit was filed by
Where is that order?
impugned order, my lord. Impugned order is at page number, is at annexure L, my lord. Annexure L, page
Find
number
your written
182.
statement in that.
Yes, my lord. I have filed a written statement also.
And how can it be independently decided injunction suit when there is a comprehensive suit is
Yes,
pending?
my lord. That is the exactly the
Have you
point.
raised that ground and say that?
Yes,
that
my
the-
lord. I have
the
raised
suit is
every
not
ground.
maintainable?
I have raised every ground on
That
this.
that suit is not maintainable.
Yes, my lord. Yes, my lord. I have produced the written statement filed by me in OS number 1076 also here
Come
at
to
page
the
number.
impugned- Come to the impugned order.
At page number 158, my lord. 158. This is the written statement filed by me in OS number 1076.
Not written statement, impugned order.
Impugned order is at page number 181, my lord. 182. Impugned order is at page number 182, annexure L. The operative portion is at page number 198, my lord.
198.
198. By this order, the court below has granted interim order of temporary injunction against me. And the respondent number 1 also filed application seeking police protection.
Ask her to come. Petition is agreed with order passed in IA number 1 in OS number 1076 of 2025, whereby the court has granted police protection and also an order of injunction in favor of the respondent number 1. It is submitted that the petitioner and the respondent number 1 are the parties to a comprehensive suit, that is OS number 75 of 2025, wherein the petitioner has sought for a declaration and injunction.
Yes, my lord.
Declaration, injunction, and also there is an order against the first respondent not to alienate the property. It is submitted that the pending disposal of the said suit, this OS number 1076 of 2025 is filed. And the petitioner has filed a written statement stating that the suit is not maintainable. maintainable, and the court, without considering all these aspects, had granted an order whereby the police protection is granted. It is a case of the petitioner that is in possession of the property, and these aspects were not considered by the court. Considering the same, there shall be stay of all further proceedings pursuant to the order passed in I number 1 invoice number 1076 of 2025 on the file of so and so. In all these cases, interim order, though I don't say, write the court's name. Whenever I say OS number so and so on the file of so and so, OS number 1076 of 2025 on the file of so and so, the petitioner is permitted to say hand summons and shall file a memo to that effect by 18th of June. If the memo is filed, list the matter on 19th. If the memo is not filed, stay granted by this court stands vacated. Yes, next.
Number 5.
My lord, in this case, I am for petitioner, my lord.
Yes.
During the pendency of the FDP proceedings, my lord, I am the respondent
Yes.
number 7. I have filed a application under order 6 rule 17 for amendment of the statement of objections, my lord. I have included the one of the property. This property is joint family property.
When did you file your objections?
During the pendency of the FDP proceedings,
No,
my lord.
during the pendency, there will be a date here for that.
The application order 6 rule 17 filed by the petitioner on 9/12/24, my lord.
2024, you file your objections.
Yes, my lord. Application, my lord. After filing the objections, and I have filed application for this amendment, included the one of the joint family property in the FDP proceedings, my lord. The court has rejected my objections and applications, my lord, on the ground that suit for partition, suit is already decreed. In the FDP proceedings, it cannot be application not allowed, my lord.
So, what is wrong with that order?
No, my lord, this property also joint family property, my lord. In the original,
What is the duty of the executing court to pass a fresh decree?
my lord, suit for partition, my lord. The one of the party has collusion with the purchaser has executed the sale deed in favor of the third parties, my lord. Intentionally, they grabbed the suit schedule property, my lord, in order to decline the share of this petitioner, my lord.
Court is right. Come. The present petition is filed. Agreed with order passed in I number 4 in FTP number 18 of 2021, dated 10th March 2026. The petitioner is respondent number 7 in the FDP proceedings. It is a case of the petitioner that during the pendency of the petition, the first respondent, his family members to grab the legitimate share of the petitioner and other respondents illegally colluded with one Manjunath, son of late Kempaya, and God created the sale deed dated 29/12/2021 in respect of the ancestral property. Based on the sale deed, he got the said Manjunath has mutated his name and MR number H16/2021-2022. And it is a case that the said property is also an ancestral property of the respondents. And executing a sale deed in favor of one Manjunath is illegal, and the petitioner herein is not a party to the sale deed. Hence, they filed this IA to amend the objections to the petition. The trial court, the executing court, by order impugned, had dismissed the said application, while dismissing the application, the trial court has observed that admittedly, the petitioner has filed the petition for the final decree proceedings to demarcate the share as per the preliminary decree passed in OS number 236 of 2014. In the IA, the respondent, the number 7, prayed to implead the property mentioned in the IA. The court observed that in the light of the settled law, new properties cannot be added to a partition suit by way of an amendment during the final decree proceedings. The court had relied on a judgment of this court in WP number 34142 of 2022 in case of Channa Veerappa Gowda versus Renukappa Gowda and others. And relying on this judgment, the court has dismissed the application. When counsel appearing for the petitioner submits that the court, it's a suit for partition, and even in this stage, the court can consider and include the said properties and the court ought to have allowed the IA that's filed under Order 6, Rule 17, seeking amendment of the pleadings, objections. Next para. Having heard the counsel for the petitioner, there is a material on record. There is no dispute about the fact that in the final decree proceedings, on the ground that one of the property is not included and is sold in favor of some other person, the present application is filed. The court has rightly dismissed the application, placing reliance the judgment of this court in Channa Veerappa Gowda's case deferred supra, and this court finds no reasons to interfere. Accordingly dismissed.
Then
Yes,
number
please.
6.
Yes.
Shankar Shastri.
Petitioner. My lord, there was a suit for partition and separate possession in the year 1989, my lord. Then there was a preliminary decree for partition in the year 1994. 95, my lord, FDP 1 of 95 was filed for drawing up a final decree.
91.
Yeah, 95, my lord, FDP 1 of 94 was filed. Then, my lord, there was change of law. A fresh FDP was filed, my lord, in FDP 4 of 2014, my lord. That FDP proceeding still not concluded, my lord. Therefore, I have prayed for a writ of mandamus directing the FDP court to conclude the FDP proceedings, my lord, at the earliest.
So what we'll do is, we'll call for a report from the concerned court with regard to this, then we will pass a mandamus.
My lord, may I pass on the order sheet, my lord?
No, not about that. What will happen is you have to understand, no, just passing an order is
Yes.
not sufficient. We should see what's the difficulty and why they are not doing. The petition is filed seeking a mandamus to conclude the FDP proceedings, which are pending from the year 1995.
No, my lord. The present FDP is 2014.
Original FDP is of the year 1995, and later, in view of the change of legal version, another FDP is filed in the year 2024.
2014.
2014.
4 of 2014, my lord.
It's a case of the petitioner that right from 2014, the execution proceedings are not concluded.
FDP.
FDP proceedings are not concluded. The registrar judicial is directed to call for a report from which court is this?
That is, my lord, Principal Civil Judge and JMFC Beltangadi.
So and so. This is matter on next Monday.
Please.
Then number 7. Basavaraju M. Petitioner.
Yes.
Appearing for petition in this case, Your Honor. My lord, in this case, one of the respondent has been is on record, whereas LRs are not on record. So only have not made the party legal heads. Chandrasekhara is dead, so for that I have enclosed a document. That is the office objection is raised. So,
No, forget about the office objection. First, you argue the matter.
yes, that only I'm arguing matter. My lord, the Chandrasekhara he died. For that, I have enclosed a document, and LRs have not come on record.
Come to the impugned order straight away.
My lord,
Come to the impugned order.
my lord, I'm seeking from this honorable court only for the expedience and the time-bound speedy disposal of final decree proceeding
When
of suit for
which year is the
partition.
FTP?
My lord, OS has been filed in 99 has been filed, and FDP in 2016. So FDP almost 10 years, and
In counsel, the petitioner submits that. The FTP proceedings are pending from 2016, and the petitioner is seeking a expeditious disposal of the same. The registrar judicial is directed to call for a report from the senior civil judge at Kadur. List this matter on Monday. Yes, next.
Number 8.
Petitioners in this matter, my lord. Writ of mandamus, my lord. Directions for speedy disposal of RA, my lords.
Which year is the RA?
RA is of 2023, my lords. After taking interim order, respondents are continuously adjourning the matter, my lord, by filing the extension application. It's almost 32 adjournments till to date, my
Might have
lords.
taken.
Sorry,
But
my
we
lords.
can't give an expeditious disposal for 23 matter. In that court, there must be so many matters that are pending from a
My
long
lords,
time.
after interim order, they are not appearing before, they are appearing before the court and they're extending the adjournments, my lord. Extending the interim order and taking adjournments, my lord.
No, for a 23
Lord's
matter, there
direction.
can't be a direction.
My lords, the OS was filed in.
Please understand that there must be so many matters on the file of the court. Why? Because you have come to the High Court. We will not direct the court to say that you please expeditiously dispose of this matter.
My lords, OS is in my favor, my lords. After 13 and a half years, the judgment was in my favor, my lords.
Because without this expeditious disposal, this mandamus from the High Court, without even understanding what is the board of the particular court, what is the pendency in the court, why are they not able to do? We can't keep on passing. So whoever comes to the High Court, expeditious disposal,
My lords,
remaining
it's
matters
not
in
the
the
court,
court's
my
fate.
lords. It's the respondents who are continuously taking adjournments, my lords.
Then file an IA in that regard before the court, and if some order is passed, then you come here. But there can't be any expeditious disposal. The writ petition is filed, seeking a mandamus to dispose of RA number 49 of 2023, pending on the file of the third edition senior civil judge and JMFC, Davangere. There are several matters pending on the file of the said court, and this court is not inclined to grant any.
My lords, due to continuous adjournment is causing hardship for petitioners, my
That is
lord.
what happens in all civil matters, not.
My lords, now he
your
has to
client
put
is
up a
not an
construction,
exception.
my lords. It is a vacant
This
site.
court cannot pass any order for expeditious disposal of the appeal that's pending in the, that is filed in the year 2023, and this court finds no reasons to issue a mandamus dismissed.
Number 9. YP Vijay Vasanta.
In this
Yes.
case, I appear for the petitions, madam.
Yes.
I preferred this writ petition challenging the order passed by the trial court on 1/4/2026 on the application filed by the petitioners herein under Order 1 Rule 10(2) of CPC, my lord.
What is the suit for?
Suit for partition and separate possession.
And who are you?
I am the co-person member. My mother is the co-person member of the suit schedule property. She died in the year 2010 without making, when she was alive, they state that they have partitioned the property in the year 2006. In the year 2006, Siddhamma, the mother of the petitioner, have not been made as one of the party to it. Without providing any of the share to the mother of the petitioners, they have got partitioned.
When was the suit decreed?
No, suit has not been decreed. A suit is still pending, my lord. That is OS number
Suit
360.
of which year?
Pardon?
Suit of which year?
16, my lord. 366. But
Still pending.
Yes, my lord.
Yes, come to the order. Come to the order, impugned order.
Yes, my lord. In this case, my lord, your lordship may kindly peruse para number 3 in the impugned order.
Page number.
Page number 17, my lord. The suit is filed by the plaintiff seeking for the relief of declaration of title in respect of the suit schedule properties. Your lordship may kindly peruse page number 31, wherein the suit is not for declaration, it is for partition and
First, let me
separate.
look at the impugned order. Which page number is the impugned order?
Page number 17, my lord.
Yes, let me look at
17.
it.
17 in para 3, my lord.
1 minute. Please come. Agreed with the orders passed in I number 1. There is no number to this IA?
Pardon, my,
There is no number to this IA?
no, my lord.
Agreed with orders passed on IA filed under order 1 to 10-2 of CPC. In OS number 366 of 2016. The proposed party is before this court. And then council submits that the applicant is having a share in the property, and without making the applicant as a party to the proceeding, the suit is filed, and the suit is very much pending before the court. The suit is filed for partition, whereas the court records that the suit is filed for declaration of title in respect of the suit scheduled properties. It is submitted that when the proper parties are not when the proper parties are not impleted, even in the execution proceedings also, they can file an application. It is submitted that this is a case where the suit is still pending, and the court, on the ground that this defendant number 10 has opposed the same, and on the ground that a separate suit can be filed as dismissed application. Next para. This court has perused the order imputed on the face of it. The court has not properly appreciated the application that is filed by the petitioner. In that view of the matter, there shall be stay of all for the proceedings pursuant to the order dated 1/4/2026 and OS number 366 pursuant to the order dated 1/4/2026 on an IA filed under order 10, order 1 rule 10-2 till the next date of hearing. Same on the file of that you mentioned.
Stay may
Notice to
kindly
the
be
res-
granted, my
Notice
lord.
to the respondent. Huh?
Stay may kindly be granted, my lord.
Granted.
Much
Notice to the
appreciated.
respondents, petition is permitted to take out hand summons. Memo shall be filed on 19th. If not memo filed, stay granted by this court stands automatically vacated. List this matter on 22nd.
Till number 10, Harish Bandareti.
Much appreciated.
Yes.
So, Lordship. Sir, Third defendant, sir.
Hmm?
Third defendant's petition, Lordship. Partition suit was filed by the party, and I am the purchaser of one of the property, Lordship.
Purchaser from which defendant? Purchaser from which?
From the defendant number 1 and 2, there's a family member.
Your defendant number 5.
3.
3.
That the suit was filed for partition and declaration that the partition suit is not binding on them, plaintiffs. I have filed written statement, Your Lordship. That written statement was filed after a delay of 6 days. The court holds that there are 120 days of period has been lapsed, so 6 days, there is a 6 days delay. On that ground, it was rejected, Your Lordship. Against which present petition is filed. My submission, Your Lordship, the Act 40 of,
Have you questioned that? That act was questioned?
yes, Your Lordship.
Where is that?
That act was questioned. I have not,
Huh.
in the one of the writ petition, Your Lordship.
Hmm.
I have produced that, Your Lordship, before the
Where is
Dharwad.
that?
I have produced, Your Lordship, that is annexure E,
Page number
page number 41, Your Lordship.
41.
Yes,
What happened to that?
that, Your Lordship, I will get it, Your Lordship. No, submit a prayer, next page only. That is, declare that the provisions of section 4 of the Code of Civil Procedure Code, Karnataka, amending this Honorable Court may please to strike down the same word annexure B. Read and down the provisions of section 4 of the Code of Civil
Where are
Procedure.
you reading?
Lordship, page 42.
It speaks about the prayer and all. Where is
Yes.
any order is granted?
Yes, Your Lordship. Then, Your Lordship. Next page, Your Lordship.
43.
Interim order has been granted.
Where do you get that?
Next page, 44, Your Lordship.
44.
Yes. That act was challenged there.
No, listen, until you challenge it, why will we, because in some other matter stay is granted, we will not. If you challenge, we'll issue notice to them and we'll stay the matter. If you are entitled for the same order.
No, because selling the same order, because
No, that is true. But we can't, we'll grant a stay and we'll not wait for that matter to, attain penalty. If you question we'll issue in the light of the other coordinate bench.
Can your lordship, I am permitted to amend one prayer, your lordship, to add the prayer.
Then counsel for the petition submitted, is agreed with the amendment to,
Prayer.
to the, amendment to the CPC, that's Order 6, Rule 17, whereby the written statement has to be filed within 120 days.
Yes.
And and he submits that he wants to amend the prayer. Does this matter when?
So, and even another next week, your lordship.
Does this matter on 8th of June?
8th of.
Yes.
8th
Check
of.
number 11, Attorney 12,
There.
Gautam M.
Yes.
Petitioners for respondent, Bescom.
The writ petition have challenged the final notice issued by the BESCOM
Mm.
in this writ petition, my lord.
Mm.
My lord, the petitioner in the year 2024, he has purchased a
1
vehicle.
minute. While posting the fresh matters also, in fresh matters, CPC at a line, thereafter writ petitions. Don't mix up both the matters. One stretch, all the matters, and then all, yes, all first file the writ petitions, list the writ petitions first, then all the CPC matters. Yes.
The petitioner, he has purchased a vacant site in the year 2020. Later in,
First, let me look at your prayer. Final notice dated 31/3/2026. Passed by respondent number 2.
yes, my lord. With regard
Who
to
is
the,
respondent number 2?
the BESCOM authority,
Bescom.
BESCOM,
What is the order that is passed?
they have issued a final note. First, they have issued a notice. Again, the final notice has been issued, for which have given the documents and have replied for the same. Now they are saying that, so we'll come and we'll disconnect without giving any further communication. Further, without any further communication.
No, they've issued a notice to
Yes,
you.
yes, yes.
You submitted your explanation.
Yes.
They
said-
have passed an order.
No, they have not passed an order.
Is it so?
So my humble submission to this honorable court, annexure A, para 3 may be kindly considered.
Page number?
Page number, I think,
What is the note? When was the show cause notice issued to
12,
him?
page number 12 of the complaint.
When was the demand or when was the
It
notice?
was 31/3/2026.
Then what happened after that?
After that, they have filed this writ petition. Sir.
I
They have
give-
filed this writ petition.
My lords, 31/3, they issued a notice for which have given a reply for that notice on
When is that?
24/4/2026.
24?
4/2026. So when I went to give this notice, they said that without further communication, we are coming.
What is this 31/3/2026
That
proceeding?
is the notice with regard to the disconnection of the electricity.
Intimation
Intimation,
Stating what?
yes.
to disconnect the,
One Mr. Naveen, who has given a representation to the BESCOM people saying that I have filed a OS with larger extent of survey number 229/2, and the OS is pending in Anekal court. The civil court has granted injunction. So you disconnect the electricity with regard to the property. There is a stay in the civil court, whereas I am not a party in that suit. I'm a purchaser of a site.
No, when you have to disconnect a power supply,
yes.
under what circumstances you can do it?
Yes. Kindly.
Is there an order from the civil court in your favor?
Kindly, just,
I mean, against
the
you?
crux of this case is, the allegation against the petitioner is that while applying for the power connection, he has furnished the notarized copy of the sale deed, which describes the schedule as 1,200 square feet. Subsequently, after issue of this letter, this notice annexure A, he come up with the document, registered document describing the total schedule as 1,260 square feet. That means the notarized sale deed copy which furnished along with the application is fabricated for the purpose of getting the power connection. That is the crux of para 3 of the annexure A. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ತಾವು ವಿದ್ಯುತ್ ಸಂಪರ್ಕ ಪಡೆಯುವ ಸಂದರ್ಭದಲ್ಲಿ ನೋಟರೀಕರಿಸಿ ಸಲ್ಲಿಸಿರುವ ಶುದ್ಧ ಕ್ರಯ ದಾಖಲೆಗಳ ಅನುಸಾರ ನಿವೇಶನದ ಅಳತೆ 1,200 ಅಡಿ ಇರುತ್ತದೆ. ಹಾಗೂ ಸಮಜಾಯಿಷಿಯೊಂದಿಗೆ ಸಲ್ಲಿಸಿರುವ ಶುದ್ಧ ಕ್ರಯ ಪತ್ರ ದಾಖಲೆಗಳ ಅನುಸಾರ ನಿವೇಶನದ ಅಳತೆ 1,260 ಅಡಿ ಇರುತ್ತದೆ. ಸೊ ಟು ಅವೈಲ್ ದ power connection if the property is either 1,200 or less than 200, they will directly issue the power connection. If it is over and above 1,200 square feet, they have to take the NOC. Their case of the respondent is after the document furnished by the respondent, it is come to know that it is the fabricated document which
For that, there won't be any notice saying that the documents which you have furnished earlier.
subsequently
no, the-
again the notice has been issued.
That is what I have asked. How, when the proceedings have started, what is that has transpired? That's what I was asking, the dates, chronology of events.
That I will,
Now, if some discrepancy, if you find any discrepancy, you will ask him by issuing a
Yes.
notice.
On
Then he will reply to that.
Yes.
For that, you will pass an order. Then the question of disconnection will come.
As per my information, only the notice has been issued, but disconnection is not made. So only they have challenged this notice issued on.
So when you issue a notice will ask, call for an explanation, isn't
Yes,
it?
yes. Subsequently, on 24/4/2026, they have come up with the clarification wherein they have stated, I have obtained connection by producing the fake and bogus
So
document.
thereafter, what did you do? After
Pardon?
you received an explanation from him, what did you do?
That I will, if your lordship permits, I will get back the detail in 3-4 days.
Till such time, you can't do anything.
But as of now, as per my knowledge,
Then counsel for
disconnection.
the petitioner submits that. The respondents have issued a notice dated 31/3/2026. For that, the petitioner has replied, has given his explanation, response, response.
Page number 40.
On
24/4/2026.
24/4/2026.
Just for a moment,
One
I am
minute,
disturbing.
1 minute. It is a grievance of the petitioner that without considering the same, the respondents are proceeding to disconnect the power supply. Land council,
Page number 40, 4 lines for a moment. Kindly.
whatever it is, you have to pass a final order on that. The land council appearing for the respondent, which respondents?
Respond number 2 and 3.
The land council appearing for respondent number 2 and 3 submits that.
One
Submits that.
Respond 1 and 2.
1 and 2.
1 and 2.
1 and 2 submits that. Between there is a discrepancy with regard to the extent of land.
Yes.
Extent of land. Earlier, the petitioner has placed a notarized affidavit. Thereafter, a sale deed is placed. Considering the discrepancy, the proceedings are issued. It is submitted that whether a final order, he does not dispute the fact that the reply is given by the petitioner. However, he submits that he would get instructions whether a final order is passed or not. Considering the fact that the petitioner has already given a reply, and as nothing is forthcoming before this court with regard to any final order, the respondents are now directed not to disconnect the petitioner's power supply till a final order is passed and a reasonable opportunity is given to the petitioner to assail the said final order. I'll dispose it of in the same lines. The respondent shall place if any final order is passed, the same shall be placed on record. List this matter on 11th.
Deeply.
11th.
11.
11 June. Yes.
13. Virupakshaya.
Yes.
Appearing for petitioner, my lordship. This is a case of writ of nature in prohibition, my lordship.
Hmm?
Writ of
Straight
prohibition.
away come to the prayer.
My
Where is the prayer?
lordship, at page number 12, my lordship.
From interfering with the petitioner's peaceful position and enjoyment of the property,
Yes, my lordship.
laying of transmission lines over the scheduled property. Why are you apprehending that they are going to lay the transmission lines
My lordship,
without following the
due
procedure?
process of law, my lordship, they have not issued any notice.
What are they doing as on today?
My lordship, they are marked the part of scheduled property.
Yes, who are the respondents?
My lordship,
First respondent,
respondent number 5 and 5
take
and 6.
notice. State of Karnataka, AGA takes notice on behalf of the first respondents. Respondents 2, 3, who takes notice? I think you only appear for 2 and 3 also. Deputy Commissioner and the Assistant Commissioner. 1, 2, 3, 4 also you appear. 1, 2, 3, 4. AGA takes notice. 5 and 6, 5 who appears? Executive Engineer, KPTCL. Huh? Mr. Devraj is directed to take notice. And 6, Resonia Anantapur Transmission Limited. Notice to 6th respondent. 5th respondent, please serve the papers. Respondents 1 to 5, then comes for the petitioner, shall serve the the papers, the writ petition. List this matter on 9.
My lordship, interim prayer, my lordship.
No interim prayer, we'll finally dispose it off.
My lordship, they
with
have started the marking and they are.
Nothing will happen, Mr. Counsel. Or if you can serve the papers and print the name of so-and-so, that, what is that name? Devraj, list the matter on 4th June. Serve the papers on the council. Yes.
14, Jai Krishnabhat.
Yes.
Plaintiff's writ petition on the application seeking withdrawal of the suit with liberty to file fresh suit has been rejected.
When is the suit filed?
What suit is filed? In 2014.
Why you want a liberty now to withdraw the suit?
Now there are certain formal defects with regard to boundary disputes and encroachment dispute. So certain documents that has been now required was not available at that point of
So you
time.
want the court to give you the whatever the latches, limitation and everything. the benefit
Because
of-
that time, my lord, the pictures were not clear.
That's not it can't be done.
So
Please come to the order.
yes.
Page number.
Now, page number 29, para 15, Lord, it commences.
You realized it so early.
So it's a rural side.
Rural or urban,
Yes.
you are assisted by an advocate. Please come to,
Yes,
come the reasoning, read the reasoning part.
para 15
7, let's read from para 7.
says. The learned counsel for the plaintiff argued that the above suit is filed for relief of declaration and permanent injunction in respect of suitable property. In the affidavit, the plaintiff has stated that he has claimed a declaration with respect to suitable property on the basis of revenue documents, but he has not pleaded correctly in the plaint with respect to that, or moreover, he has not filed the documents in properly earlier documents. Hence, there is a formal defect in the suit, and defect cannot be cured by way of an amendment. Hence, he prays to allow the application. Learned counsel for the defendant argued that the application is at belated stage after conclusion of the evidence and final arguments on the defendant's side. The plaintiff has filed this suit by suppressing material facts regarding title to the suit land by falsely alleging that he is ancestral property. When his false assertion is exposed in the cross-examination, he disclosed that he acquired the suit land under a compromise decree in civil suit in 2017. False allegations of encroachment of the suit land by the defendant is also exposed by court commissioner's report. There is no sufficient ground to and reasons to allow IA. Hence, they prayed to dismiss the application. The plaintiff has filed IA seeking permission to withdraw the suit with liberty to file fresh suit on the same cause of action and for the same relief. The relevant provision of law on this is sub rule 3 of rule 1 of rule order 23. The said rule provides that where the court is satisfied that the suit must fail by reason of some formal defect, or be that there are sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject matter of the suit or part of the claim, it may on such terms as it seems fit grant plaintiff permission to withdraw such suit or such part of the claim with liberty to institute a fresh suit in respect of subject matter of such suit or such part of the claim. On careful examination of the IA affidavit filed by the plaintiff and the objections of the defendant, the grounds on which the suit is sought to be withdrawn with liberty to institute fresh suit stated that he has claimed declaration with respect to suitable property on the basis of revenue.
Not a case.
Lord, may I kindly pass over, Lord, if they want to withdraw me, or otherwise.
Ask them, but I'm going to discuss it.
Yes.
Yes. Next.
Cell number 14. No, 14. Sorry.
15.
Cell 15.
For the petitioner,
Yes.
suit is for partition.
Hmm.
The petitioner is being aggrieved by the order passed by the trial court dated 1/7/25, that is at annexure A. That is by allowing order 1 rule 10 application filed by the defendants. the trial court has allowed the application wherein,
Please come to the order.
this one, page 24, ma'am.
Let's read the order. Come to the reasoning part.
My lord takes para 10, page 28, my lord.
Yes.
However, considering that defendant number 1 has set up a counterclaim seeking share in the property standing in the name of proposed defendant number 3, and the said person is the registered owner as per the sale deed. My contention is, my lord, the proposed defendant number 3 is none other than the husband of the plaintiff, my lord. And just by filing a counterclaim, the learned trial court has said that he is a proper and necessary party.
No, property which stands in the name of a proposed party is part of this
No.
partition. That's what the court says.
No, my lord. The this
Let's see
proposed.
the IA that's filed by him.
Yes, ma'am.
Where is IA?
IA is at page number 59, my lord.
Let's read. What is this case?
Yes, my lord. Para 3, my lord. State that the parties acted on the said arrangement and pursuant thereto and on the insistence of the plaintiff, site number 92 was sold and the entire sale proceeds were divested to purchase the written statement scheduled property in the name of the husband and proposed defendant number 3. The plaintiff now has result from the family arrangement and has filed the above suit to deny first defendant his rightful entitlement to the suit scheduled property. So their whole.
According to him, as defendant is a number 3. What is defendant? Who is number?
Defendant number 3 is the husband of the plaintiff, my lord. He has purchased the site on his own.
Divested. On the side. Para 5, you please tell the court what is it. Para 5, please read and tell the court.
The suit is liable to be dismissed in the alternative. The first defendant has filed a statement of counterclaim claiming 2/3 share in the written statement scheduled property, which stands in the name of proposed defendant number 3. Proposed defendant number 3 scheduled property is different, my lord. Now their
that property is now the suit scheduled property. That's a counterclaim property.
Yes, my lord.
So why the property is in the name of so and so? Why he cannot be a party, and what is the prejudice that is caused to you?
If the property which I purchased, that is defendant number 3, which has been purchased, that is purchased out of his own funds, and it's a separate property residing where plaintiff is residing right now.
In a partition suit, seeking partition of that property also, a counterclaim is filed.
But that's not a joint family property. Which
who will decide that? Not at this stage.
Yes. But there's no document produced by them.
No, at a stage order 1 rule 10, we can't decide all that. So there no disadvantage to you. The present suit is agreed by the order passed on IA number 8. The plaintiff is before this order IA number 8, in OS number 8321 of 2019, dated 1st July 2025. The plaintiff is before this court. The plaintiff had filed a suit for partition, and the defendant, as defendant number 1, has filed a suit for has filed a counterclaim seeking partition of a written statement scheduled property, and the defendant has also filed an IA to implead defendant number 3 to implead
defendant number 3.
To implead defendant number 3 as a party to the proceeding. Why? He's already a defendant. What is this defendant number?
They again filed an application to amend the plaint. I'm saying he's not a necessary party at this stage. Let the trial be commenced and evidence.
No. He is a defendant number 3. And
no, after implement is a defendant number 3, right?
No, after everything is carried out, now you're questioning.
It's not carried out right now. Just an order has been passed.
No, you're all referring to him as defendant number 3.
Yes.
Even in the order also, he's referred as defendant number 3. Why?
No, after
the proposed party, you won't call proposed defendant number 3. is it proposed defendant?
Proposed defendant.
The defendant number one has filed an application to implead her husband as, is the husband of plaintiff or
Plaintiff.
has filed an application to implead the husband of the plaintiff as defendant number three, as she sought the counterclaim of, she sought a counterclaim seeking partition of a property where the plaintiff's husband, that is the proposed defendant number three, is the owner of the property. The trial court, by order impugned, has allowed the said application. Aggrieved thereby, the plaintiff is before this court. Land counsel appearing for the plaintiff submits that the property is the property of the proposed defendant is a is his property, and that is not a part of the joint family property. Hence, he is not a proper and necessary party to the partition proceedings. And the court, without considering this aspect, has impleaded the has allowed the IA and impleaded him as a defendant number three. It is submitted that a person who has nothing to do with the joint family properties cannot be impleaded as a party as a party to the partition proceedings. This court, next para, having heard the land counsel for the petitioner, has perused the material available on record. By order impugned, the court will allow the application, and while allowing the application, the court has observed that the plaintiff is seeking partition of the property bearing number 488, HL second stage, Indira Nagar, Bangalore, alleged to be the joint family property. The defendant number one has filed counterclaim with regard to different property allegedly acquired in the name of defendant number three, based on family arrangement. The court has observed that, considering that defendant number one has set up counterclaim seeking share in the property standing in the name of the proposed defendant number three, and the said person is a registered owner as per the sale deed, and the court is of the view that he is a proper party to for the limited purpose of adjudicating the counterclaim. This court, in the considered opinion of this court, the court has rightly considered the fact and rightly allowed the application. When the defendant has filed a written statement and the written statement scheduled property, the owner of the property is the proposed third defendant. He has to be he is a necessary party to the partition suit, and no prejudice is caused to the plaintiff. According to the plaintiff, it is a self-acquired property of the proposed defendant. Whether it is a self-acquired property or whether it is a joint family property would be decided by the court during the course of trial, and all those things cannot be gone into at this stage. In that view of the matter, this court do not find any reasons to interfere with the order impugned, accordingly dismissed.
Then number 16, P.B. Shivkumar.
Yes.
At the commercial court matter, the plaintiff is before the court. Suit was filed. A counterclaim independently was filed. Our grievance was in the counterclaim under section 6A. Pre-institution mediation had not been gone in. The defendant ought to have sought for pre-institution if he had a counterclaim or urged a pre-institution in the counterclaim. He does not, he files his counterclaim independently. A counterclaim is a suit. But we brought to the court's notice that without a pre-institution, 6A has been invoked and a separate suit of a counterclaim is sought for. The learned judge rejects our application as against the charge. That's the only question that's to be answered.
Yes.
Whether counterclaim is independent and whether he would have invoked section 12A.
Let's read that.
Beg your pardon.
Let's read that order.
Order. I'll just point out what the learned judge comes to the conclusion. May I take only to the portions at page 39, ink page 39, para 12.
Yes.
That is the reasoning of the learned judge.
Let's read.
In the present case, as evident from the PIM report filed by the plaintiff and defendants have participated in the pre-institution mediation proceedings. They have undergone the process of mediation, but for the various reasons, mediation could not result in a successful outcome. Therefore, when the parties have already mediated prior to filing of the suit once again, when the subject matter of both the suit and counterclaim arise out of the same transaction, requiring the parties to undergo mediation for the same purpose would be an exercise in futility, also would be a waste of precious judicial time. Hence, for these reasons, I am of the considered opinion that it's not mandatory for the defendant to undergo separate PIM proceedings prior to filing counterclaim. Therefore, the counterclaim cannot be rejected on the ground that defendants did not recourse to PIM proceedings prior to filing of the same suit. A counterclaim arises on account of suit being filed when subject matter of the claim and counterclaim
So he was,
are.
or parties were subjected to a mediation.
But we had subjected ourselves for pre-institution mediation. They were served. And in the pre-institution mediation, they did not, it's a non-starter report. But the non-starter report would amount to a pre-institution mediation. But if it is rejected, or if it's not considered, if they had put forward their claim independently as a counterclaim.
Pre-institution mediation has not worked out. That's why you have filed the suit. The suit is numbered.
I had to file a suit.
Yes, suit
ultimately.
is numbered. Now, with regard to the very same cause of action,
Yes.
and he has a counterclaim. So
He
why,
did not ask for a counterclaim in the pre-institution. He did not ask. That's our case.
no, that is one. That is
Yes, yes.
your argument is he has not asked for.
Yes.
But if you ultimately look at it, what could not be settled for this? Even if this the other way also, it
But
would not settle.
that pre-institution is insofar as my claim is concerned in the plaint. His claim is concerned is not a pre-institution mediation. It should have been independent is what.
Now, if it is again sent for mediation.
Yes, ma'am. That can be. He should
Yes.
make a plea for that.
Hmm?
He should make an urge for that. He should make an application. He can make an application without making
What is the
application.
law on that?
But the law is not settled on that issue.
So, in the facts and circumstances, when it is not working out between the parties, why should he has filed a counterclaim, let it go on?
No, that's what we have asked. Throw it now instead of going for adjudication. That's what I have sought for.
If I have any judgment or any law on that,
Yes,
let's
ma'am.
look at it, place it when you want.
Next week, any
Yes,
date
let's
next.
just matter on 9th of June.
Then
At
number
request of
17.
London.
Instead of 9th, no, 12th, my lords.
12th.
Then number 17, State Jayasimha.
Appear for the petitioner. My lord, this writ petition, my lord, is filed against the rejection of an application under Order 7 Rule 11 filed by the plaintiff seeking, my lord, rejection of the counterclaim that had been filed by the defendant. Lordship may just give, I'll give you lordship a small list of dates, my lord, that will tell you lordships why
Suit
we are
for-
making this application.
What is the suit for?
My lord, we as a plaintiff filed a suit for recovery of certain sums of money under an MOU, my lord, that had been entered into between the plaintiff and the defendant. Your lordship may kindly look at the dates, my lord, that give your lordship the answers to your lordship's question. My lord, the suit was filed in 2012. Petitioner filed COM OS number so and so against the respondent for recovery of monies due under the memorandum of understanding executed between the petitioner and defendant. Now, my lord, 17/4/2013 is a very relevant date, my lord. On that day, the defendant, who is a respondent in the petition, filed written statement pleading that it was entitled to recover INR 1172.79 crores. Your lordships may please be kind enough to look at the written statement, my lord, that has been. Please be kind enough to turn to page 70.
Complete these dates.
Yes, madam, I will.
Yes.
Madam, they filed a counterclaim. They filed a defense saying that no amount is payable to the plaintiff. On the contrary, we are entitled to recover 1,172 crores. No counterclaim was filed. Then, my lord, they filed an application in 2016, after 3 years, seeking to amend the written statement to file a counterclaim. That, my lord, your lordship may kindly see the date. That application was filed, my lord, on 29/7/2016. And that application was granted by the learned trial court.
By order dated?
By order dated 10/11/2020. That is serial number 5.
You have not questioned it.
It was questioned. It was questioned before this honorable court, and the order passed by the learned trial court was set aside. Thereafter, my lord, the respondent took up the matter in appeal before the honorable Supreme Court by way of SLP. SLP was granted, and SLP was allowed, my lord, on the ground that there was no finding that had been recorded by the High Court on the question of limitation. Your Lordship may kindly look at the order passed by the Honorable Supreme Court. In that, if your Lordship will be kind enough to turn to Annexure J, my Lord,
Page number.
at page number 182. It's a short order. If your Lordship will permit me to read it, my Lord, I shall be highly obliged. Para 3, my Lord. The appellant is the original defendant and the respondent is the original plaintiff. A suit praying for a money decree was filed by the respondent. After filing the written statement, an application was made by the appellant before the trial court for amendment of the written statement for incorporating a counterclaim in accordance with Rule 6A of Order 8 of the CPC. The trial court allowed the application by order dated 10/11/2020 in a writ petition on Article 227 of the Constitution of India filed by the respondent. By the impugned judgment, the High Court has interfered and has held that the counterclaim was barred by limitation, and therefore the same cannot be taken on record. On a plain reading of the impugned judgment, we find that there are absolutely no reasons given by the learned single judge of the High Court to come to a conclusion that the counterclaim was barred on the day on which the application for amendment of the written statements was filed. Faced with this difficulty, learned senior counsel appearing for the respondent submitted that admittedly counterclaim is barred by limitation. He relies upon the pleadings to show that the counterclaim was barred by limitation. His submission is that taking the benefit of the pendency of this appeal before this court, the appellant has delayed the trial of the suit, and while making an application for stay of the suit, relevant facts are not brought to the notice of the court. It is true that if the counterclaim, now this is important, this paragraph is important. It is true that if the counterclaim proposed to be filed by the appellant was barred by limitation, the trial court ought to have rejected the application for amendment of written statement. However, we find that the impugned judgment that while interfering with the order of the trial court, the High Court has not recorded a finding as to how the counterclaim is time barred. In this appeal, we cannot for the first time look into facts and record a finding on the issue of bar of limitation. The application for amendment of written statement was filed by the appellant more than 8 years back, and today we are at the same stage where we were 8 years back. Hence, to avoid any further delay, no purpose will be served by remanding the writ petition to the High Court. Proper option would be to allow the amendment while keeping the issue of bar of limitation open, which can be agitated by the respondent at the appropriate stage. As regards the prayer of the respondent and the counterclaim being in the nature of a cross suit can always be separated, we leave it open to the trial court, etc. etc. Therefore, my lord, the critical point is that the Honorable Supreme Court said, while we are not going into the question of limitation, we will allow the application for amendment. You take up the plea of limitation at the appropriate stage. Therefore, application for amendment granted. We then, my lord, before the trial court, filed an application under Order 7. And your lordship may just see para 9, my lord. That's also irrelevant. I'm grateful to my learned friend, my lord, for pointing it out to me. We, however, make it clear that the issue of bar of limitation with a counterclaim is expressly kept open, which can be agitated by the respondent in accordance with law. Therefore, my lord, the question of limitation is kept open. We have made an application before the trial court as plaintiff under Order 7, Rule 11, saying please reject the counterclaim on the ground that it is barred by law, barred by the law of limitation. The trial court, my lord, has dismissed that application. It is against that we are before you.
What was the finding of the court?
Of the trial court, my lord, I am sorry to say that the only finding which has been recorded by the trial court without any reasons is mixed question of law, in fact, therefore dismissed. Please see the order. If your lordship will be kind enough to turn, my lord, to the impugned order, which is the Annexure A, which begins at page 27. In fact, my lord, if your lordship will kindly see the order.
Page number?
Page number 27, it begins. Paragraphs 1 to 23 are all, my lord, setting out the facts and the pleadings between the parties. And then, my lord, your lordship may kindly turn to the relevant paragraph, which is para 24, which your lordship will find at page 50.
No, ultimately, where is the finding?
My lord,
where is the finding?
my lord, para 24 is the only finding that I can discern at page number 50.
Yes.
Accordingly, Honorable Supreme Court has observed that in civil appeal number so and so about the limitation can be agitated at appropriate stage. Therefore, the law of limitation is the mixed question of law and fact.
please come to your rejection of your IF under Order 7 Rule 11.
Under Order 7 Rule 11, my lord, your lordship gets it at Annexure K, which is at page 188. In the written statement that they filed originally, this same amount with the claim by way of counterclaim.
Are you relying on anything other than that is stated in the?
No, I am relying only on what is stated in the written statement.
In the counterclaim.
In the written statement. And to show that the plea in the written statement is the same as the plea in the counterclaim, and therefore, even according to the, your lordship may kindly look at it, my lord. If your lordship will be kindly look at paragraph 3 at page 190. It's a long paragraph. I think it will be sufficient if your lordship will kindly go to page 191 at second line on top of the page 10, my lord, the Roman 10, your lordship sees. Yes. This is the subject matter of the counterclaim now. From April 2010 to July 2011, defendant is entitled to recover 245.90 crores from the plaintiff. Thus, the defendant is entitled to recover a total amount of 1172.79 crores from the plaintiff. That is 876.89 crores recovered for the years 2000 and 2010, and 245.90 crores recovered for the period from April 2010 to July 2011, together with interest at the rate of 18% per annum. This was the plea made in the written statement.
It is not your case that they have filed the written statement on.
They filed the written statement, my lord, on 17/4/2013.
17/4/2023.
No, my lord, they filed the written statement on 17/4/2013.
2013.
Yes.
And they have filed an IA under Order 6.
Order 6 Rule 17 on 2016.
Counterclaim.
My lord, the application for
counterclaim was filed on 29/7/20.
3 years later.
So are you on that ground, or are you on the ground that whatever the amount that is stated, like the amount, the cause of action accrued in the year 2010, that's why it's barred by limitation?
That's correct.
On what ground? This
is ground, the written statement ground. In the written statement itself, they are saying that the amount that is due is for the period from April 2010 to 2011, and for the period from 2010 to 2011. Now, if the amount, even according to the admission in the written statement, is that it was a amount that was due.
What will happen if the court frames an issue on that?
No, my lord. What happens, my lord, is now that's the question, my lord. Now your lordship may kindly look at the judgment of the Honorable Supreme Court. My lord, this has been cited before the trial court, not been considered, and I want your lordship to kindly see that, my lord.
Yes.
If your lordship will kindly see the, give me the copy of the citations. Citations. Lord, if your lordship will kindly look at it, take it. Doesn't matter. Your lordship may kindly turn to page 143. Your lordship may kindly see even the head notes, but I'll then take your lordship to the relevant paragraphs if necessary.
There are earlier judgments of the Supreme Court on.
No, my lord, that is in a situation, I'm aware, my lord. In fact, I must tell your lordships in all fairness that there is a recent judgment of the Honorable Supreme Court also of His Lordship Justice Narasimha. And then, my lord, there is another judgment of in 2026 of His Lordship Justice Mahadevan, sitting with His Lordship Justice Pardiwala, where, my lord, the pleading was that I came to know about my entitlement on a particular date, even though the claim pertained to a period which was beyond limitation. Knowledge came only on a particular date. Therefore, the Honorable Supreme Court said the question of knowledge is a mixed question of law and fact, and therefore has to be gone into. In this case, that question doesn't arise. You knew about it even when you filed the written statement that you are entitled to 1,172 crores, because that is there in the written statement. Now, if you knew on that day and you kept quiet about it, what I am not relying on any other material excepting the pleading in the written statement in order to reject the counterclaim on the ground is barred by limitation. That is the point, my lord, that has been stated in this judgment at page 143. If your lordship will kindly see, my lord, the head note at the bottom of the page, I'll read that and come to the relevant paragraph.
Yes.
It is well settled. This is because in respect of counterclaim, my lord, section 3 makes a specific provision. I showed your lordship the 3 of the Limitation Act. It is well settled that section 3(1) of the Limitation Act casts a duty upon the court to dismiss a suit or an appeal or an application if made after the prescribed period, although limitation is not set up as a defense. I'm reading on the head note, my lord, at the bottom of page 143.
Yes.
May I read it again once again? No. It is well settled that section 3(1) of the Limitation Act casts a duty upon the court to dismiss a suit or an appeal or an application if made after the prescribed period, although limitation is not set up as a defense. In the instant case, such a defense has been set up in the written statement, though no issue was framed in that regard. However, when the trial court had, in terms of the mandate of section 3(1), come to a finding that the suit was barred by limitation, it was the duty of the first appellate court and also the high court to go into the question of limitation and decide the same before reversing the judgment of the trial court. And then, my lord, your lordship may kindly turn to paragraph 22. Specifically with reference to Order 7, Rule 11D.
With regard to this whole checkered history of this case.
Yes.
Please take out notice on the council. I'll take it up on Monday or Tuesday. We'll dispose it off.
Yeah, because we have one anxiety that I want to place before you. I understand. We will do that, my lord. That is best is to dispose of the case. So we all know where we stand, my lord. I agree, my lord. But I'm given to understand that the trial court case is posted on 10th. So if your lordship will give me a date before, then I shall be obliged.
The petitioner is permitted to learn a senior counsel appearing on behalf of the petitioner has argued, has submitted how the order impugned is back and which is and how it is contrary to the law laid down by the apex court, considering the fact that this is a commercial suit of the year.
This is a commercial suit, my lord, of the year 2013,
2012. At this stage, this court is not inclined to stay the proceedings, and this court deems it appropriate to hear the other side and dispose of the matter finally. List this matter on 8th.
8th
coming up on?
10th.
10th.
Yes.
Let it be on 8th or 9th.
Whatever suits your lordship.
List this matter on 8th. Counsel for the petition is permitted to serve the hand summons on the counsel appearing for the respondents before the trial court and shall file a memo to that effect by 5th of June. If it is filed by 5th, list it on 8th.
There's only one request if I can make, my lord. Your lordship said your lordships are not inclined to grant an interim order. Would your lordship leave that question open? So in the unlikely event, the matter is not taken up on 9th, this finding that is recorded by your lordships today should not come in this.
This court deems it appropriate to hear the other side.
Yes.
And dispose of the matter.
Great.
And if the memo is not filed by 5th, it will not come on 8th.
No, madam. We will do it. Of course, we will serve a copy on the other side and file it.
Yes.
Number 18, Siddharth Suman.
Please, my lord, apologize for being present on VC, my lord.
Yes.
My lord, this is a writ petition filed by the plaintiff before the trial court. My lord, the plaintiff had filed a suit for declaration and injunction, whereby, my lord, the honorable trial court was pleased to grant an order on I number 1 of 25, where, my lord, the honorable trial court granted an injunction as sought for by the plaintiff on 13/1/2025. Now, what happens is, my lord, my entire relief is as against defendant number 1, which is respondent number 1 before my lords. But what happens here, my lord, on 6/2/2025, which is the next date, I filed another application seeking for police protection because I was not able to implement the order because there was still interference despite the interim order and despite me having complied with, my lord, the provisions of Order 39/3A. Now, what happens subsequent to that, my lord? I filed the application. The honorable trial court says, see, unless and until the other side comes on record, I cannot hear you out. Now, initially, my lord,
Suit is for?
the suit is for declaration and injunction, my lord. And
what is IA?
What is to prevent them from interfering with my possession, which was granted, my lord. May I just take my lords to the order, my lord?
Order was on 31/2025.
13/1/2025, my lord.
13/1.
I filed the application on the next date itself.
When did they enter appearance? They have not entered appearance.
They have. So as far as defendant number 1, my lord, he enters appearance on 26/6/2025.
26/6/25.
25. Now what happens, my lord? As far as the others are concerned, they are still not on record, but they are, my lord, the predecessors in title of defendant number 1. So as far as the threat is concerned, it's only from defendant number 1. As far as defendant number 2 to 5, they are his predecessors in title. Now here, my lord, by the time I effect summons as far as different number 2 to 5 is concerned, they will, into what has happened today, my lord, I have in fact produced photographs also back then, but for some time, my lord, I had some reprise because I'd gone to the police station, my lord, jurisdiction police station. To some extent, my lord, they were able to control it. Now, my lord, they're insisting on an order from the Honorable Trial Court saying that
No,
unless
whatever order this court grants, it is like virtually allowing your writ petition.
my lord, what happens here, my lord, even if, so, because there is this finding to this
Please,
effect,
please take out notice on first respondent. You come
Yes.
back tomorrow, day after tomorrow. We'll hear the matter. Because now whatever order I pass, it is like allowing your writ petition itself.
I understand, my lord, but the only difficulty, may I just take my lords to this one observation made by the Honorable Trial Court, my lord, because that is what is now coming in my way. In fact, if my lords were to direct the Honorable Trial Court to consider my application also, that's fine. My lords may kindly come to page 23, my lord. This is the difficulty.
No, whatever it is, I cannot pass any order without notice to the respondents.
My lord,
That's why
please,
you please take out hand summons on defendant number 1.
please,
Let him be here. We'll pass an order. I'll take it up on 4th.
please, I'll do that, my lord. I'll do that.
Land counsel for the petition is permitted to take out hand summons on the. Now only respondent number 1 is served.
My lord, only he is being served. As far as the others are concerned, I have to take substitute service.
On respondent number 1, and shall file a memo to that effect. If the memo is filed by tomorrow, list this by 3rd, list the matter on 4th.
May I, my lord, serve it on the counsel who's representing them before
Counsel
the trial?
representing the first respondent before the trial court.
Please, wait for me.
Then Jagdish Balika.
May I please?
Yes.
The LRs of the original judgment debtor are before your lordship. What happened is the respondent filed a suit for specific performance. That came to be compromised within 10 days of the filing of the suit. Then, after the death of the defendant therein, he filed execution petition. Now the problem is the schedule which was explained in the agreement and the actual schedule is something different. It's altogether different.
That would be decided by the executing court.
It has to be decided, but I made application, that application came to be rejected.
What is your application?
My application is filed under order 22 rule 2 22A. Order 21 rule 22A. Your lordship, annexure A is under challenge.
Read the reasons.
Reasons.
Paragraph number 7, please read. It's a suit of 2010.
2000, yes, please, 2010.
So what happened to that order where this application for appointment of the court commissioner was allowed?
That is allowed.
You are not agreed with that?
No.
You were
No.
there and the order was passed. You were already implemented.
Please, we were on the we were on record.
So you are not agreed with that order?
No
It
petition.
is a consequential order. Now you're.
But that is not challenged so far.
What is commissioner warrant was issued to the court commissioner for execution of the sale deed?
Please. Now my submission to your lordship is, the schedule is altogether different. The schedule which was the suit schedule earlier and the actual schedule is different.
Where did you say so? Let's see that. Your IA.
Your lordship will get annexure G at page 33.
Let's see, where did you say?
Yeah, I'll read the affidavit. Your Lordship. That I am the legal, may I read?
Hmm. Such a vague application, how can it be considered by the court? You just say set aside the sale, set aside the document, and you don't even give any particulars. He has executed a document. If there is any dispute with regard to the boundaries, you can, if the court commissioner is appointed and exactly the land is mutated, land is demarcated, that's a different issue. What all you have stated, so how can the court consider all that? Look at your para number 2.
Yes,
That can't be done. Please
no,
continue.
but Your Lordship, only my request to Your Lordship. I may be permitted to file a proper application explaining, because now.
For
see,
that, you have to take notice to the respondents.
Please,
When counsel, the petition is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect by 10th of June. If it is filed, this is matter on 11th of June.
Number 20, Anil Kumar R.
Hearing for petitioner lordship, a suit
Yes.
for specific performance lordship. I was placed ex parte lordship. Thereafter, respondent has filed execution lordship. In suit as of the 2023 lordship.
When was it? When was the decree?
Judgment came to be passed on 22/3/2025 lordship.
When were you set ex parte?
22/3/25 lordship. The page number lordship.
No, you said
33 lordship.
decree is dated 23/2025.
Yes, lordship.
Uh.
I was placed ex parte lordship. And
When
order
was-
has been passed lordship. Ex parte judgment and decree has been passed.
Let's see, where is that order?
Page number 40, page number 33 lordship.
Page number?
33 lordship. Judgment lordship.
You're
Annexure
questioning-
C lordship.
No, you are questioning it by filing the writ petition.
Lordship, in execution, I filed IA number 4 lordship under order 20.
Where is that order?
That order is at page number 25 lordship, annexure A.
You should have filed an application also to set aside the ex parte.
Miscellaneous I have filed lordship.
When did you file that?
Miscellaneous, page number 63 lordship, annexure K.
Give the dates.
Date lordship, 17/12/2025 lordship,
17/12,
2025.
and that is pending till
Yes,
now.
lordship. They have filed the objection lordship. I have filed a stay for lordship.
Only thing is what we can do is we can ask the court to decide your IA. We can't pass any order now.
Yes.
Take out notices on these people. We'll dispose of this matter. I'll take up this matter on 10th of June. The petition is permitted to take out hand summons, same order. By 9th, you should file the memo. If it is filed on 9th, it's the matter on 10th. Yes, next.
List number 2, for orders matter, seal number 1.
For petitioner, tenant's revision petition, my lord. My lord, subsequent to the interim order passed by this honorable court, the tenant has vacated the premises. Only thing I have to hand over the key, but the respondent owner is not ready to refund the security deposit amount. If that is done, my lord, matter
What is the security deposit?
1,35,000, my lord. That he is not ready to.
What is the finding with regard to that?
My lord, kindly come to page number 26, my lord.
Let's see.
Basically, there is no agreement, rental
Plaintiff
agreement
is
between
decreed with
the.
cause. The defendant is
There is
hereby
no
directed to quit and deliver the vacant physical portion of the petition to the plaintiff within 1 month from the date of the judgment. fails to do so, then the plaintiff is at liberty to file execution petition. Is at liberty to separate petition to so and so.
There is no agreement at all in writing between
What agreement in writing?
a rental agreement.
Then what is not there, or how can we tell them to do it?
My lord, he admitted that he received 1 lakh.
What about admitting? There should be some finding somewhere.
My lord, I have produced the document before the trial
We
court.
cannot do. Now you are questioning an order that's passed by the trial court, isn't it? Where is the finding which we have to interfere now?
My lord, if the owner refund the amount, my lord, I will hand over the key. I have already vacated, my lord.
That is not at all the issue anywhere.
That is the issue, my
Where
lord.
is the issue? Please come to the order.
My lord,
Where is it discussed? What is the finding on that?
kindly come to page number 23, my lord.
23, yes.
Page number 23, para 23. In a suit for eviction between landlord and tenant, unless there is a contrary, all that is required to be proved by the landlord.
With regard to the money,
Yes,
para
madam.
number 24, please come to that.
24. Accordingly, in this hand, there are no indications to interfere that there was an agreement to the contrary, and defendant failed to prove that there was any agreement contrary to the same. Even the defendant has failed to prove that he has given the advance amount of rupees 1,35,000 and hand loan of so and so.
So this is the finding.
This is the finding.
So when
Madam,
they-
in the WhatsApp message, the respondent has admitted.
Oh, we will not look at the WhatsApp messages. We are in a revision.
Yes.
We are in a revision. All
Yes.
this you should have adduced all this evidence, if at all any, for the trial court.
It was done.
Where is that?
It was done.
Which
That
exhibit is that? Let us see.
It was done, my lord, but for that matter, LCR is required, my lord.
Huh?
For that, LCR is
No, you are
required.
saying that it is there is nothing, it
I
can be closed.
produced the evidence before the trial court, but the trial judge has not considered it.
Exhibit
Therefore,
P1
LCR
So and so, P2 rejoinder notice, P3 postal receipt.
Therefore, LCR is necessary, my lord.
Let it be called for this year. Yes, registry is that to call for the
My lord,
LCR.
interim order is there up to today, my lord. Anyway, my learned friend has appeared. If
And you have already handed over the portion.
no, my lord, not handed over. I have vacated. Key is with me only. I have shifted to another house. During the pendency, my lord, my father died.
Kindly see the paragraph.
No, I could not vacate immediately.
By keeping the keys with you, what you want to do?
My lord, if he refund the amount, security deposit, I will hand over now.
I can understand you are staying in the premises. You are not staying in the premises.
Yes.
If you are entitled for that refund of the amount,
Ah.
that we would be deciding it eventually while deciding this revision. But there is no purpose of you keeping the lock and saying that I have.
My lord, if I
vacated the
hand over key now only, he will not refund.
If there is a court order, even if you return the key or you don't do it, if there is no material, court will not say anything. So
Madam-
it is all subject to what will be decided by
My
this
lord,
court.
kindly have this matter next week. By that time, LCR will come and I will.
This is matter on
12th, my lord.
12th of June. Not 12th, it's not possible. This is matter on 16th of June.
16th. Interim order is there.
Interim
up
order
to-
only granted is extended till now.
Cell number 2, CM Nagbhushan.
Give that letter.
Anytime, call for LCR, my lord.
Call for that. Yes. That means where it should go. That's what it is happening. Earlier it is happening like that. A letter is addressed by the Principal City Civil and Sessions Court, Bangalore, date 22/4/2026, seeking extension of time to dispose of OS number 6167 of 2019. Coordinate bench of this court had disposed of the writ petition on 9/10/2025, whereby Where is that order? Letters won't be even clear. What is the time they want? Within 1 year from the date of receipt of the copy of the order. The learned judge has sought for 4 months' time, considering the reasons stated. Another 4 months' time is granted for disposal of the suit. Yes, next.
Cell number 3.
This also letter.
There and be. Confirm.
A letter is addressed by the so-and-so seeking extension, letter dated 28/3/2026. Why they have kept placed before the courts very early? It's 28/3/2026 letters. Why are they doing it? A coordinate bench of this court tell the registrar judicial why they have not placed. A coordinate bench of this court has disposed of the petition on 19 February 2025, issuing a direction to the trial court to dispose of the matter as expeditiously as possible, not later than 6 months from the date of receipt of the copy of the order. Now, the letter is addressed seeking extension of time. And sought for 6 months' time accordingly. Considering the request, some time is granted. However, the learned judge should ensure that without seeking further time, the suit shall be disposed of. Yes, next.
Cell number 4. Satish DJ. Cell number 4.
After lunch.
Malaj, may I make this submission in serial number 15, Malaj? Malaj,
No
due to
mention.
certain inadvertence.
ಮೇಡಮ್ ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಒಳಗೆ ಕೇಸ್ ನಂಬರು ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಒಳಗೆ
complaint also would simply say Schedule B surrounded by Schedule A on all sides. Not even a sketch has been provided.
The IA now.
Now, the application that has been filed by the plaintiff is seeking injunction to restrain me from putting up any construction on Schedule B property, which is admittedly my property. And the trial court has granted the IA, the injunction. I have filed an appeal before the first appellate court. My appeal was dismissed.
Let's see that order.
Kindly see the
Let's see from the reasoning part.
page number 57, para 14.
No, I'm looking at the appellate court's order.
Appellate court, sorry. The appellate court has made a finding that both of us are not able to show the boundaries, which is also incorrect because I have shown revenue records to show the sketch. Para 14, page number 44, my lord, para 14. I'll start from para 13, page number 43, my lord.
Yes.
A certain position of law has been upheld. In the circumstances, it deems just and proper to judgment of this honorable court in so and so. In the absence of establishing the correct boundaries of the property, a decree for injunction could not be granted in favor of the plaintiff. Now, having held this position of law, if the plaintiff fails to show the boundaries, it is the plaintiff's suit which has to be paid. I cannot suffer an order. Kindly see para 14, my lord. Reasons. By this, it is certain that in the absence of establishing the correct boundaries of a property, an injunction cannot be granted. Herein, though the plaintiff sought for injunction disputing the boundary, circumstances required defendant number 2 operant to show his exact boundaries by cogent and reliable materials placed on record. Merely by producing private documents like survey sketch. My lord, survey sketch is not a private document, it's a government document. Conversion order and drawing inference from the conduct of the landlord on his legal heirs does not make good his case to destroy the plaintiff's case. Defendant number 2, who contended that exact location, had to show his definite case, whereby the prudent man would believe him undoubtedly. At present, the circumstance narrated by defendant number 2 is like asserting certain facts, making one to believe or raise the presumption in his favor, which is not permissible at this premature stage. The materials on record must undoubtedly disprove the plaintiff's case, whereby defendant number 2 ought to have located exact place boundary before beginning the construction. This is the sum and substance of the entire reasoning given by the appellate court. The trial court also has made a similar finding, saying that boundaries are not determined by the plaintiff. No document has been produced by the plaintiff to show any boundary. And even the commissioner who was appointed has not given a conclusive finding. Now, when there is, if in reality there is no cogent material to show boundary, it is the plaintiff who has to fail, not the defendant. Onus cannot be shifted upon me. And I have relied upon.
Let's go to the order passed by the trial court.
And I'll kindly see order passed by the trial court at page number 57, para 14.
Please read.
The plaintiff has produced RTC extract bearing 94/3. This is the sole document in the plaintiff which has already been set aside by this honorable court. And it appears that the name of the plaintiff measuring an extent of 0.24 acres and the name of the defendant number 1 measuring 0.5 acres of land. There is no dispute with respect to RTC. Even plaintiff has filed petition before DDLR court for plotting.
No, except this RTC, there is no other document of title in favor of the petitioner.
Of the plaintiff, not a single document. One sole stray RTC record which has already been set aside by the revenue authority.
Further.
Even plaintiff filed petition before DDLR court for plotting of 0.5 acres pertaining to 94/4, but appeal number 4712 of 24, the same order has been remanded for fresh inquiry. Hence, it requires to be known to know about actually where 0.5 acres of land exists in the survey for 94/3. This court has appointed the court commissioner to file a report with respect to to identify the 0.5 acres and where actually existing. But prima facie, there is an ambiguity in the commissioner report. Hence, it requires full-fledged trial to know about where 0.5 acres of land is existing and in that house was existing. Even though the counsel for defendant number 2 has produced conversion order copy, when the matter is pending before DDLR court for fresh inquiry, the exact location sketch is required to come to the conclusion. At this stage, if construction work of house is stopped, no hardship would be caused to the defendant. Plaintiff has produced photographs of the plain scheduled properties which
Now,
goes.
what is this case that you're going to make construction?
My lord, it is my residential house which I have to live there, my lord. I have no other place to live.
Now, what are you doing now?
I am putting up construction.
You're taking up new construction or
Yes.
renovation?
There was an existing old house which I have renovated and now I'm putting up fresh. Most of it is fresh construction, but there was a house which was in existence from time immemorial.
Yes.
And I have been living there. Now temporarily I have shifted elsewhere, but it is my, I cannot,
What is the stage of the construction? It is not yet commenced.
it has fully commenced. We have about to finish. In about 4 or 5 months, we will complete it.
Next.
At the same page, bottom both line, my lord. The ownership of the properties are not disputed by both parties. Here, the dispute arises with respect to exact location of the house. Hence, there is no need to discuss about the title deeds of this stage. If the defendant has succeeded, automatically the suit will be dismissed.
At para 15, the court says.
Yes, madam.
But counsel for plaintiff has argued that exactly where the plain B scheduled property is existing is to be decided by the DDLR court. Now that is already decided.
The DDLR court has decided in my favor.
That's what I'm saying. It is
Yes.
decided.
Yes, that was during pendency of the, after this order was passed, during pendency of the appeal before the appellate court.
What is the order of the DDLR court?
It has confirmed the exact location and drawn a sketch also of where exactly my property is. Hence, there may be ambiguity in boundaries. Now, both courts have found that there is an ambiguity regarding boundaries. If the plaintiff is not able to establish boundaries, the plaintiff should fail. Onus cannot be shifted upon me because.
Let's see the plaint.
When I kindly see the plaint at page number
The plaint,
63.
let's go to this IA that's filed seeking injunction.
Just for one moment, my lord, kindly see the plaint at page number 63. The schedule is at 67, 66 and 67. Schedule A is allegedly of the plaintiff. Immoved property of so-and-so village, survey number 94, 3 portion Tari, assessment 16. Boundaries, remaining portion of same survey number is south, east, west, subdivision so-and-so. B schedule, which is admittedly my property, my lord. Boundaries, north, south, east, west, portion of the same survey number.
How can be boundaries like this?
It cannot. It does not even comply with Order 7, Rule 3. Straight away, suit should have been dismissed.
Remaining portion of the same survey number. South
All
east,
sides same survey number. There is absolutely no way to ascertain such a vague boundary. Clandestinely, they are taking an injunction against me by giving very vague boundaries.
Come to the IA now. And in the plaint, show the court what is the, according to how he is in occupation of the property and what is the source of title.
In the plaint, there is absolutely no reference to how the plaintiff became the owner.
Having acquired the same by way of succession after the death of her husband.
This neither her husband nor any successor of her husband was the owner. Admittedly, the property stood in the name of one Chennakeshwaraya. It belonged to one Shamaya, and now the RTC has been restored to the name of Shamaya, deleting the name of the plaintiff. And maybe it was in Kannada. I have one translation.
In respect of both.
In respect of the Schedule A property, plaintiff's name has been deleted from the sole revenue record that she had in her name. The revenue department has set aside her name and restored it to the original owner's name, which is Shamaya. There's absolutely.
Please come to this.
Absolutely no averment to show how she is related to the Shamaya.
IA.
I is at page number 128, my lord. It is not restricted to Schedule B. It is the entire suit scheduled property. Restrain the defense and their main agent and all persons claiming through and under them from constructing the building in the suit scheduled property. It is not restricted to A or B. The plaintiff, even assuming the plaintiff is the owner of Schedule A property, plaintiff could have asked for injunction only in respect of Schedule A property, leaving out Schedule B property. Even if her description of Schedule B property was correct, and even if she's admitted to be owner of Schedule A property, she could not have asked for injunction over my property. She could have only restricted herself for seeking injunction against Schedule A property, leaving out Schedule B property. Here, clandestinely, she has attempted to overreach and ask for injunction against the entire suit schedule property. Now, admittedly, I am owner of Schedule B property, and still I am restrained from putting up construction in my own property.
Well, hear him. Yes.
My lord, my learned friend has suppressed some material facts. My lord, I am the owner of the entire property. My grandfather Shamaya was the landlord before the land tribunal. Krishna Devadiga made an application for grant of land. His house property was granted about 5 cents out of 29 cents. That we are not disputing it, and that house was in the edge of the northern side. That property was there, even in the sketch. What the petitioner has done, who is the second purchaser from Devadiga to intermediate purchase, then petitioner has purchased. He made a platting of this land in the center of this 29 cents. He wants to knock away the entire property. That plotting done by the ADLR was questioned by me before DDLR. DDLR passed an order saying that without hearing me, that plotting has been done in the middle of the land. Therefore, that was cancelled. Page number 115, Miller. If you have yes.
To what you are submitting?
In
the center.
DDLR order was challenged before this honorable court because it was passed against a dead person. This honorable court set aside the DDLR order and remanded it back. After remand, it has been passed in my favor.
No.
Kindly see the DDLR order, my lord.
Have you any instructions on that?
Afterwards, no orders have been.
To him a copy of that.
Where is? After remand, no order.
This order is passed.
Yes, let him show it. I will look into.
Tomorrow?
Yes.
Yeah, tomorrow, my lord.
Got her tomorrow in list number 2. 2 is? In the adjourned list. Yes.
Number 8. Revanna Ballari.
In this petition, I have challenged the orders of the trial court. Taking the WS
What
is
are
not
the
filed.
office objections?
Office
Why are you
objection
not
is
complying
only
with?
in the prayer column. I have not mentioned the case
Code
number.
3 to be made good.
Please, I will, right now I will.
Synopsis to be in chronological order. All these objections shall be complied within 2 days.
Right now I will comply. I have already complied the
The
other
court
objections.
fee you will pay to the court officer.
Yes, court fee is paid, man.
That is
court
what is the objection?
I have paid the court fee, man. I am having the receipt.
So
also.
whatever are the objections, please
Please.
comply. Yes, what is the matter about?
Matter is for the WS is not filed from the defendants in the trial court, my lord.
Hmm?
It was WS has not been filed
Hmm.
by the defendants in the trial court in OS number 246. There the court has been noticed that WS is not is taken as not filed on 5/2/2026 and also 16/3/2026, my lord, within stipulated times. Before that, my lord, along with the Wakarat, the application was filed under order 7/11 of CPC to reject the plaints. By that time, the stipulated time is over, so that the trial court has been taken that
So what is to be done?
the trial court order it cannot be proceeded for the further stage of the WS is taken as not filed. The matter is tomorrow or day after tomorrow.
You have not filed the written statement within 120 days.
Yes, ma'am. Yes, ma'am.
Now the court will not permit you to file the
Yes,
written
ma'am.
statement.
That's why I have challenged that.
So
order.
why should we, on what ground? That is the amendment. Have you questioned the amendment?
If at all the permission is not granted, because the court has been adjourned.
Whatever you want to do.
Along
I will not
with the-
stay. I will
along
not
with
stay
the-
because there is nothing wrong with the order.
Along with the Wakalat, my lord, I filed the application.
Whatever it is, 120 days, you have not filed the written statement
Yes,
is an admitted fact. And as per the amendment, you have to do it.
Yes, ma'am.
And what are the reasons why we should interfere with the order? There are no reasons.
And the order is only the interim order is to be passed, not to proceed
Notice to the
on the
respondents.
ground of WS is not filed.
The respondent and the petition shall comply with the office objections within 2 days, or else The writ petition itself shall stand dismissed without further reference to the court.
Kindly fix a date, 12th of this month.
This is the matter. Notice to the respondents. Petition is permitted to take out hand summons. This is the matter on 18th of June.
Cell number 9.
My lords, I appear on behalf of the petitioner, my lords.
Yes.
My lords, the office objection is only with respect to the IA numbers, my lords, saying that there are two IAs being, an appeal is being preferred on two IAs in one writ petition, my lords. The issue is, my lords, I'm not challenging both the IAs in one writ petition, my lords. The order is a common order, my lords, which was passed only on one IA. The same submission was written, my lords, and based on the council submission, it is being put up, my lords.
IA2 to be clarified at prayer. IA1, more than one IA challenge in single WP to be clarified. IA2 to be clarified at prayer.
Please,
What
my
is a prayer?
My lords, in the prayer, I seek for seeking of quashing of the order passed on IA number 1 and 2, which is a common order, my lords. If my lords may kindly.
No, for example, there are two IAs. You are agreed by only one IA. Why
Please,
should you
ma'am.
mention two?
No, my lords, what I sought for is both, my lords, but a common order also was passed. But one IA was not even considered, my lords. If my lords may please indulge me and come to page number 23, my lords, I will show the order.
Either you are confused or you are confusing the court.
No, my lords. My lords, if my lords, I'll just clarify that, my lords. If my lords may kindly come to page 23, my
Here
lords.
your submission should be that because it's a common order, I need not file two writ petitions.
Please, my lords.
Or
That
I
is
am-
what, that
I
is
am
what
seek-
is my submission.
That is not your submission earlier. Now you are saying.
No, in
You
the
said-
council submission that was written is that only, my lords. Saying it's a common order passed by the learned trial.
There is no submission here.
It may be considered as my submission, my lords. Apologies. My apologies, my lords. The submission is that it's a common order which was passed, my lords.
What are the two IAs?
My lords, one IA is for a temporary injunction, my lords. The other IA is not to release water from the adjoining site into my site, my lords. That were the two IAs. In fact, what we had pressed for hearing and the learned trial court had heard was.
Two IAs.
Please, my lords.
There are two orders virtually. Though it's by way of a common order, when you apply for the order copy, they'll give you two.
No, my lords, it's only one. That is the-
One, but you will have a copy for that because there are two independent IAs.
Please, my lords. In fact, I produced it, my lords, at page 20.
That's it. No, it unnecessarily like these are all civil proceedings, not that in a writ like we just
Please,
for our two three no, prayers we file one writ petition.
Please, in fact, my
Office
lords, I will only
objections-
intend to press on IA
office
number.
objections shall be complied with.
My lords, in fact, my lords, my submission may be taken on record, my
Let's
lords.
just mark it after tomorrow. You tell the district. Yes, next.
Cell number
My apologies, my lord, my lord.
Cell number
My
10.
lord, serial number 7, interim order may kindly be extended. It's
Interim
posted
order
for-
earlier granted is extended.
My lord, serial number 10, my lord, there are two office objection, my lord. Second one is statement of objection has to be filed, but there is no written statement is filed, my lord. Regarding the office objection, first one, my annexure should be stated in the prayer, my lord. If you permit, I will do the changes now, only, my lord.
Then number 2.
Later tomorrow, there is no written statement is filed by, only emergency notice issued to respondent.
As far as objection number 1 is concerned, the petition shall comply with the same. Objection number 2, learned counsel submits that no written statement is filed.
First one I will submit.
Accordingly, second office objection number 2 is overruled. Yes, argue the matter.
I will do it next tomorrow.
You can as well argue it. Why should we again keep on listening
senior
so
is
many times?
Tomorrow I can take it, my lord.
In all these orders matters also, if you please be ready with the main writ petition to argue the matter itself. This is matter on 5th. Yes.
Cell number 11.
Serial number are same, my lord. First office objection is urgency, my lord, which is filed in the vacation bench. It can be overload, my lord.
Office objection number 1 is overruled too.
Second office objection is that annexure should be mentioned in the prayer, my lord.
Shall be complied with within 2 days.
Today I will do it, my lord.
Yes.
Third one is challenging here to be filed, my lord. Is already filed as annexure C, my lord, in the page number 56.
It is submitted by the petitioner that the objection number 3 is already complied with. This is matter on the same day, like in the other matter. Yes, next 12.
Cell number 12. Somshekaraya Arpit.
Complied with the office objection, I have filed memo along with IA filed under IA number 11.
But the
Along
petitioner submits that the office objections are complied with. Are you ready?
Yes, my lord.
Yes, give the file.
Yes. I think whether it is put up or not, I don't know.
What is that?
Yeah, I have filed, along with memo, I have filed the document, my lord. Whether it is put up or not, I don't know.
Is this matter day after tomorrow? Yes, next 13.
Cell number 13. R.K. Mahadeva.
Yes. No representation for dismissal. It's 14.
Cell number 14.
Petition. Office objections are complied with. Court fee is paid.
Land counts for the petition submitted to the office objections are complied with.
My lords, the petitioners are
You're ready?
challenged. Please, ma'am.
Yes. Yes.
My lords, the petitioners are challenging the order passed by the appellate court, whereby a mere notice has been issued on my IA for stay, and they have listed the matter after 5 months. Lords may kindly see page 58, my lords.
50.
58, impugned annexure B. 58 is the order.
You approached the appellate court.
I
against
approached the
interim
appellate
injunction.
court. There was a suit filed by the respondent 1, 2, 3 for bare injunction against respondent number 4. And a IA for 39, 1 and 2 was filed, whereby they sought a stay of, not to create charge over the property. In the suit for the stay bare injunction, my lords, an IA seeking not to create charge over the property was filed. I was not made a party to the proceedings. I am the purchasers of site formed over the suit schedule property. A GPA was executed by the plaintiff in favor of the defendant in 2013. For registered GPA, I have produced, my lords. I have produced at page number 60, my lords. Registered GPA, which enables the defendant to even form sites, get the lands converted and sale. Thereafter, he has got the lands converted by DC conversion in the year 2014-15. And he has formed site, and we petitioners have purchased sites. Several sites have been
When
formed.
did you purchase?
2016 itself. Registered sale deeds, I'll produce the copy.
Yes.
In 2016-17 itself, in December 2016 few, and in January 2017 few of the sites we have purchased. Now, my lords, what has happened, my lords? The plaintiff, who was the owner, files a suit for bare injunction against the defendant. He admits he has executed registered GPA. He admits in his plaint. He admits that he has issued a notice of termination in the year 2023. All these aspects have been admitted. Defendant appears before the lower court. He brings it to the knowledge of the court that there are several sites have been formed and sold to third parties. Despite the same, the court goes ahead and passes an interim order not to create charge over the suit schedule property. My lords, by that way, I am affected. Challenging this order, I file an MA. I was not.
When was the order passed by the trial court?
My lords, annexure A, passed on 5th November 2024, my lords. I am not a party to the proceedings. Immediately, I got to know in the year 2025 April, I filed an impleading application. My impleading application was filed in June 2025.
325?
I filed my impleading application in June 2025. That came to be rejected.
No, I think you said 5th November 2025.
That is the order passed on 39, 1 and 2, my lords.
That's what I'm asking.
5th November 2024.
24.
24, my, sorry. 5th November 2024. Annexure A, that is also under challenge in this matter. Page number 32. This order I come to know in the month of March, April, my lords. I file an impleading application on June. That is on, my lords. I filed my 11th June 2025. My impleading application came to be rejected on 9/3/2026. Immediately, I file a writ petition and I have obtained an order of stay of further proceedings as of now, my lords. And what I do, my lords, after this, I file an MA challenging this order of 5th November 2024.
When was that?
After in 27th of April 2026, my lords. I file an IA along with the MA seeking stay of the order passed on 39, 1 and 2.
When this matter is posted now?
Now, my lords, 28th of September, my lords. Orders passed on, kindly see page number.
No. Take out hand summons. We'll dispose of this by fixing the timeline to the court.
Please, my lords. Page number 58. My only concern is this, my lords.
No orders in this. Please come. The petition is permitted to take out hand summons on the counsel appearing for the trial court and shall file a memo to that effect. Once a memo is filed, let's this matter. When do you want?
Well, it's after a week or two, my lords.
Yes, let's this matter on 16th.
Please, ma'am.
If the memo is filed.
Please.
By 12th of June, list the matter on 16th. Yes, next.
So 15. Shri Rajshekar.
Non-consideration of grant of the ex parte order. What's the petitioner plaintiff claims that he has rights to buy the property under an agreement of sale, where substantial amounts has been paid, and the bank account extracts for having transferred the money, which is correlated to the amounts which has been transferred under the agreement, was also produced before the court. Note, there was a requirement that before the sale deed could be executed, because that's even the statutory requirement to bring about the registration. The entries were not fully made out in the name of the vendors, which had to be effected before the specific performance.
Agreement holder.
No, I'm an agreement holder. The requirement of he completing certain obligations, which will enable the process of registration to take place, was not completed. With that in the situation, he executes one more agreement in favor of a third party. I go before the trial court and file a suit for injunction saying that until and unless this is fulfilled, there is no way I can seek for specific performance. By reserving liberty to seek for specific performance, let him not alienate the properties to third parties. The trial court, if your lordships were to see, what happens is, the trial court hears the matter on the previous day, that is a day before the vacation commenced, at page number 22, my lords. And the order is at page number 23. Lords, I am restricting my writ petition only in respect of IA number 3. IA number 4, my lords, I am not pressing for the present. Page 23, the last 4-5 lines, this is all the finding recorded.
Which court is this?
Lords, this is by the rural court, my lords. Bangalore rural court. Page 23, heard and perused records. Plaintiff has not made out a prima facie case. Therefore, before passing orders, it's necessary to hear the reference.
Then the
Lords,
injunction is granted, appeal to this court.
Lords, if an injunction is granted, then appeal is to this honorable court.
So it is IA number?
This is IA number 3. I am only pressing on IA number 3, which your lordships will find at page number 39. I am only seeking for a relief that he should not alienate or encumber the property. At page 41 is the relief.
Let us see your plaint.
Lordships will kindly see that the plaint commences at page 25.
Yes.
Out of 2 crores, 10 lakhs, 60 lakhs is paid in one shot. The remaining is to be paid immediately after they get the rectification of the entries, which is the pleadings forthcoming at para 5.
As per the agreement of sale, within what time the document has to be registered?
Lords, it is 6 months.
Agreement is dated 28/6/2025.
Yes.
When is the suit filed?
Lords, the
2026.
suit, Lords, this is with the condition that he has to get the rectification. What happens is, unless the revenue entries are rectified, nothing moves forward because this is a revenue property. We can do nothing in respect of this property unless he seeks the rectification of the entries. He doesn't even make an application seeking rectification of the entries.
You have paid the money.
We have paid the money.
You have deposited the money. The
Lords,
remaining
we have not
amount.
deposited the money. We have made a pleadings, Lords, that we are ready and to pay, ready and willing to pay the consideration.
What is the remaining amount?
Lords, the remaining will be about 1.5 crores.
You have paid only 50 lakhs then.
60 lakhs.
Substantial. It can be substantial amount. It's
Lords,
not even half of it.
for the Lords, if the property was ready to be sold, probably it would have higher consideration would have been paid and agreement. This is a property where they will have to take certain steps to keep it prepared for the sale because revenue entries are not yet in their names. They have the title, but there are no revenue entries in their names. That is what is stated, Lords, in paragraph number 5. If they keep it ready, we'll have to pay the money and then get it concluded within 6 months thereafter.
The agreement of sale says so that that's the obligation of.
There
the
is,
owner.
Lords, there is.
Please come. The petition is before this court. Agreed with as the trial court has failed to grant. injunction against the respondent not to alienate the property pending disposal of the suit, and a notice is ordered. Then senior counsel appearing for the petitioner submits that an amount of rupees 60,000 is 60 lakhs is paid by the petitioner herein, and the remaining amount out of
2 crores 10 lakhs.
2 crore 10 lakhs has to be paid within 6 months. 6 months. It is submitted that as per the agreement of sale, the respondent has to fulfill certain obligations. Only on fulfilling of the same such obligation, then only a registered sale deed can be executed. Because of the laches on the part of the respondent, they could not, the process could not be completed. And now the first respondent is making all efforts are already done.
No, he's only entered into an agreement with the third party.
It is submitted that the petitioner, the first respondent, is entering into agreement with third parties. If the same is done, it would cause a lot of hardship. But this aspect was not appreciated by the trial court. Considering the submission to the senior counsel, and unnecessarily if the third party rights accrue, it gives a multiplicity of proceedings. There shall be an injunction restraining the first respondent or the only respondent.
Lords, restraining, there are multiple respondents.
Respondent is the executor.
Lords, I just point out is it is the whole family, my lords. The defendants number 1 to 6.
There shall be an injunction restraining defendant number, the respondent number 1 to 6 herein.
1 to 8, 1 to 7, my lords, up
1
to
to
Sandhya.
7 herein, who are defendants 1 to 7 before the trial court from alienating the property.
Please.
Alienating the property. The petition shall take out hand summons on the counsel appearing for the respondent before the trial court. They are not served so far.
They have not yet served. Your lords,
Shall take out hand summons on the respondent. First, the registry notice to the respondent. The petitioners, in addition, the petitioner shall take out hand summons on the respondent and shall file a memo to that effect by 23rd of June. If the memo is not filed by 23rd June, the stay granted by this court stands vacated. This is matter on 24th.
Lords, it's great.
Bill number 16. Just Prashant.
Appear for respondent. Today I filed Wakalat. Kindly order to put up the Wakalat, my lord. And maybe posted on 4th.
This objection shall be complied within 2 days, or else the writ petition shall stand dismissed on that ground. Next 16, yes.
My lord, matter is on, they sought for sale proclamation, spot sale and court sale. Now kindly taken up on 4th, my lord. Matter is on 10th.
The spot sale is on 10th, my lords.
Yes.
Matter can
4th,
wait
I'll
till
file
4th. Should not
my
be a problem.
statement of objection and documents. Because
File it on 4th, then we'll have it on 9th so that you serve on him. And if has any,
Lords, 9th maybe because 10th the spot sale is kept. Lords, of course.
8th, my lord.
Yeah, very well.
this is matter on 8th
8th, my lord.
at the request of land counsel for the respondent.
Kindly, my name should be shown. KP Bhuvan.
Registry is directed to reflect the name of Mr. Bhuvan for all the respondents.
Yes, ma'am.
Yes.
Please.
Bill number 17.
Lords, I'm appealing for petitioners, my lord.
G. Balaji Naidu.
This matter was moved on vacation bench, my lord. There was a minor office objection with regard to 1 and 3. May be permitted to 3 days time to be granted for complaint. With respect to office objection number 4 and 5, my lord. 4 is with respect to urgency is not stated, my lord, because of the vacation bench. That may be overruled, my lord.
Objection number 4 is overruled. Yes,
And
next.
objection number 5 with respect to service of the caveat petition. We have been served to the.
Objection number 5 is also overruled as a notice as papers are served on the counsel for the respondent.
Yes, my lord.
What about 1 to 3?
1 to 3, 3 days may be granted, my lord. 3 days maybe.
Objections 1 to 3 shall be complied with within a week.
3 days.
Yes.
My lord, this matter pertains to a commercial case, my lord. Impugned order is at page 16, my lord. Prayer is at page 10, my lord. The order of issuance of delivery warrant with respect to the commercial premises, page 16, my lord.
Issue delivery warrant in respect to the You are the judgment debtor.
I am the judgment debtor, my lord. This ejectment suit was filed by the respondent, claiming the position and the arrears of rent, my lord. Matter with respect to post-COVID sessions, my lord, I am unable to pay because of the COVID reasons, my lord. These are running PG, my lord. And because of that issue, my lord, I could not able to pay the rents. Then, my lord, I have filed an injunction suit, my lord. That injunction was been granted in my favor in the 2023, my lord. Subsequently, my lord, the respondent has filed the commercial case suit, my lord. That has been decreed. That is on order at page 60, my lord.
When was decreed?
That is, my lord, 29 August 2025, my lord. Against this order, my lords, we have appeared. We approached this honorable court and filed an appeal, my lord. There was an interim order also operating on this case, my lord. May I just pass on this interim order, page 65, my lord. There is an interim order of stay only with respect to page 66 is operating, my lord. The stay was granted only with respect to the men's profit, which is my lord.
Profits and arrears of rent are concerned, we consider it appropriate to write to recovery the same eviscerate subject to the depositing entire decretal amount with the registry within a period of 2 weeks.
Yes, my lord. That was not been complied, unable, but extension application also been filed and matter is listed for tomorrow, my lord. All that I am seeking only till the pending disposal of the appeal, statutory appeal, my lord. Some reasonable time to maybe granted. That's the only case I am before this court, my lord.
How can you seek that before this court?
My lord, I am ready to pay whatever the rents is now. I'm now also, despite the order also, my lord, I'm paying the rents, my lord. Partly I'm paying the rents.
No,
Whatever the amounts is pending.
Which order you have questioned?
I am questioning page 16, my lord. Issuance of the delivery warrant by the executing court, my lord. Because there was no stay with respect to handing over the possession, my lord. Based on the application.
What can't be done in the regular appeal, you will do it. In the
No. I am only seeking time, my lord. Only reasonable time will be granted. Whatever the.
Ask for that wherever they are.
My lord.
What is this numbered as? Appeal.
Appeal. My lord, till such period, my lord. Matter is listed tomorrow.
You are before the High Court.
Yes, my lord.
Here, one switch, you will go to the other floor.
I'm sorry, my lord.
No.
My only endeavor is, my lord, at least some breathing time. There are students are there, my lord, in the PG, my lord.
No, that's the same thing will be appreciated by the Honorable Chief Justice. Go there.
My lord, at least matter is listed tomorrow. Matter maybe have it on next week, my lord. Next week, my lord.
This I'll have it day after tomorrow. This is matter day after tomorrow. It is submitted that the connected matter is coming up before the other bench tomorrow.
Grateful.
Yes, next.
My lord, sir, till office objection may be
The other
complained.
objections 1 to 3 shall be complied with within 2 days. Or else on that ground, this writ petition shall be dismissed.
Grateful.
My lord, petitioner may be, my lord, requested to convince this court regarding maintainability of the writ petition.
That's what, that we will do it day after tomorrow.
Please.
Grateful.
Yes.
18 order, cell number 19, SV Prakash. 19.
Petitioner, my lords, I made an application seeking amendment of writ petition, my lords.
Amendment of writ petition.
Please, my lords. In fact, the respondents, before filing the present suit, they instituted a suit before the vacation court and withdraw that suit without seeking liberty, my lords. On the same cause of action, they filed the present suit, and the trial court has granted the interim.
No, that I understand. What is this IA1 for amendment?
That facts I want to brought into the petition, my lords, and I want to have some grounds also on based on that, my lords. While filing the writ petition, I have not at that ground, my lords.
Oh, you want to amend the grounds?
Please.
By the IA number 1 of 26.
That's
what you want
Please.
to amend the pleading,
Petition,
the grounds that are raised
Please.
already. IA number 1 of 25 is filed, the amendment of amendment. Considering the reasons stated. Allowed. Yes.
Great. My lords, the respondents instituted suit seeking permanent injunction against me, claiming that they are the purchasers of the suit schedule property from one daughter of one Maranna. I'm the defendant. We are the defendants 1 and 2. We appeared in the suit and we contended
What is the
that
suit number?
OS number 354 of 24, my lords.
Your defendant number?
1 and 2, my lords.
1 and?
1 and 2.
1 and 2.
Please, we appeared in the suit and we contended that there is an unregistered will in favor of second defendant executed by that Maranna. the suit schedule properties are the self-acquisition of that Maranda, and they have no right over the suit schedule property. The trial court initially granted ex parte temporary injunction and made it absolute after that. I filed objection. We preferred the miscellaneous appeal. The miscellaneous appeal came to be dismissed. Now my ground is that, my lords, their suit itself is not maintainable because, my lords, when there is a cloud over his title, they can't seek permanent injunction only, my lords. They have to seek declaration also. Unless there is an extraordinary circumstances, the trial
The
court.
judgment of Anathul Sudhakar is, I think now.
We cited in the appeal, my lords, but.
No. I think there is a change in legal position with regard to that judgment of Anathul Sudhakar.
By the 2025 three judges bench, my lords, the Supreme Court held that unless there is an extraordinary circumstances, the trial court can't consider, my lords, because in this case they have only simple grounds that we are interfering their possession like that, my lords.
No. I'm saying about that Anathul Sudhakar's case was reconsidered in some other judgment, and they know they have that law is diluted. I think
My
in
lords,
some other
as
judgment.
per my knowledge, there is a three judges bench judgment, some asthma something, my lords, in the Supreme Court, 2020-25 judgment. There is a.
I think revisited. The judgment is again relooked into.
Date may be given, my lords. I'll look into that and.
Yes. When do you want?
So, 4 days next week, my lords.
Let's it on 11th of June.
Grateful, my lords.
Cell number 20. Abdul Amin.
The respondent has filed an application for seeking for vacating the interim order that was
Where
granted.
is the respondent?
Not to be seen.
Sheetal Sunil Soni.
No representation on behalf of the respondents. This is matter on 24th of June. Interim order earlier granted is extended.
Cell number 21.
Here. Petitioner, my lord. My lord, the petition is filed challenging the order passed by the trial court, my lord, for not permitting me to mark the certain documents, my lord.
What is this? IA 3 of 26.
My lord.
The LRs of R2 to D on record.
Yes, my lord.
Notice is ordered in that.
Madam, pardon.
Notice is ordered.
No, my lord, not yet.
To set
It has
aside
not
the
come for,
abatement.
my lord, it has not come for preliminary hearing, my lord.
Then why when you then
Because
when the order is passed, whether he was alive or not?
they have been made as a party before this court, my lord. However, they were not the parties before the trial court. The concerned person is died in the year 2024, my lord. However, I have made a party, but they have not been made a party before the trial court, my lord. Now, office has raised recent objections, my lord, that there is a continuation of delay. There is a delay in bringing the last.
You are questioning a particular order.
Yes, my lord.
Then how can you just like that make them a parties to this revision, to this WP?
I'm not.
Which order you are questioning?
IA 16, my lord.
Where is that?
That is at page number 49, my lord. I have filed an IA, my lord, seeking permission to mark certified copies in lieu of the original documents which have been submitted.
Read. Whoever are the parties before the trial court, you will make them a parties. And you want to implead somebody for whatsoever reason, you will file an IA.
Yes, my lord.
Straight away, how can you show them in the cause title that these are the respondents and file an IA to bring the LRs on record? How the office has numbered all this? You can't do it.
Since office has raised objections, my lord, I have filed IA, my lord. Later, again, office has raised objections, my
First of
lord.
all,
There is a delay.
Your cause list, your cause title should be as it was before the trial court.
Yes.
Anything else, you have to file an IA, court has to entertain that. First of all, as it is filed before the court, is not maintainable. You can't array the parties as you wanted. When you're questioning, when you're in a 227 before this court, but you're questioning a particular order by the trial court.
My lord, only I am challenging the order.
Whatever it is,
Yes,
first
my
of
lord.
all, the procedure you have to follow.
I'll withdraw the
And,
applications, my lord. I'll withdraw the applications, my lord.
Withdraw the?
I'll withdraw the applications, my lord. If
Withdraw the application, then what will happen to the cause title? You have to change everything. In comes to the petition submits act, he wants to amend the cause title. You have to file a separate, I'll allow you, I'll give you permission to file a fresh petition. Withdraw this. Because it's all messed, you can't do it also.
Yes, ma'am.
Because there must be amendments in your petition with regard to all these people.
with the liberty to file fresh petition.
The petition is dismissed, then council submits that. the parties who are not parties before the trial court, as they are necessary parties, he has shown them in the cause title. And as they are no more, he has filed IAS to bring them on record. The petitioner, if they want to implead any parties who are not parties to the IA before the trial court, has to come up with an application, but he cannot on his own make them as parties to the writ petition. In that view of the matter, the writ petition is dismissed with a liberty to the petitioner to file to file a fresh writ petition questioning IA number
16, my lord.
16 of
16 of 2023.
16 of 2023 within a period of 10 days from the date of receipt of the copy of this order. The registry is directed to return all the documents.
Gotcha.
All pending IAs are disposed. Yes, next 22.
Cell number 22, Narendra Babu, HL. 22, Narendra Babu.
Lord, respondent, please, my lord. He filed, my lord, a suit for specific performance in the year 2006 in respect of 10 guntas of land in survey number 32, please, my lord. In survey number 68 is concerned. My lord, on filing of the suit, please, my lord, the petitioners herein, my lord, they entered into a compromise. My lord, agreeing to sell, my lord, 5 guntas of land, that is east.
You are the defendant.
I am the defendant in the suit, please, my lord, where a compromise decree was drawn. And, my lord, a boundaries, my lord, which was referred as, my lord, east to west 40 feet and north to south is concerned, please, my lord, 5 guntas of land is concerned. My lord, based on the compromise, please, my lord, respondent, he files an execution petition is concerned. Immediately, please, my lord, the daughters of the petitioners herein, they file a suit for comprehensive suit for partition is concerned, wherein they challenge the, my lord, the compromise decree also. My lord, ultimately the suit got decreed, against which, please, my lord, no appeal was filed, and my lord held that the compromise petition which, my lord, petitioner and the respondent herein had entered into was declared as null and void is concerned. Thereafter, please, my lord, FDP petition was filed by the daughters of the petitioners hearing, first petitioner. FDP, my lord, commissioner was appointed. He demarcated the property is concerned. FDP petition was allowed, allotting, please, my lord, shares to the, my lord, parties is concerned. Thereafter, please, my lord, an appeal was preferred by the respondent herein. That appeal was allowed, making certain observation is concerned. Now that appeal against that order of remand is concerned, there is an appeal preferred by the daughters of the first petitioner, please, my lord, before the coordinate bench of this court is concerned. Now the execution petition is being filed. Now he is proceeding with the property is concerned, please, my lord. Why? Because the respondent herein gets only the undivided share, please, my lord. Now he is not having any specific share is concerned and he is entitled only to an undivided share. Therefore, please, my lord, petitioners, in view of the pendency of the appeal, my lord, before this court, and also, please, my lord, the order of remand which is being challenged. Now, since the FDP petition is also pending, my lord, the petitioners herein, they filed an application seeking for stay of the execution petition. That application came to be rejected, which is being challenged in the present writ petition is concerned. My lord, annexure K.
Page number.
118, please, my lord.
Yes.
IA 15, please, my lord. My lord, the portion below, my lord, relevant would be point 6, point number 1. My lord, it is the contention of the JDR that the decree holders are intending to obtain the sale deed. My lord, the page number, my lord, there might be some difference. Why? Because immediately after
You're reading which paragraph?
Para 6.
Please read.
It is the contention of the JDR that the decree holder is intending to obtain sale deed with respect to the, my lord, page 120,
Yes, sir.
respect to the scheduled property, which is the ancestral property of the JDR. The said original property belongs to the father of the JDR, namely Rangaya, and he had 4 sons, namely so and so. After the death of Rangaya, his sons have divided the ancestral properties and the JDRs have obtained the suit scheduled
That is
property.
not paragraph number 6.
My lord, the page number, my lord.
No, I'm not. I'm
My
not.
lord, it is the continuation. Why, my lord? I admit, please, my lord, there is a mistake in placing the, my lord, the certified copies in a chronological order. There is a mistake.
No, forget about it. It is paragraphs won't change.
Please, my lord.
Paragraph number 6 starts like it is a contention of the JDR.
Yes, please, my lord. Yes.
After that, obtain sale deed
My lord,
with respect to the scheduled property.
that would be
Yes,
at page
that is
120.
at 120.
That
Yes.
would be at page 120.
You can read now.
In the meanwhile, the decree holder in collusion with the witness and document writer entered into an unregistered agreement of sale with respect to the joint family properties and also filed in OS so and so, and the suit came to be compromised. When the matter came to the knowledge of the one of the daughter of the JDR filed suit in OS so and so for the relief of partition and has challenged the decree of OS so and so. After hearing the parties, the said suit came to be decreed allotting 1/5 share to the daughter of the JDR. The DHR has preferred RA number so and so before the concerned court against the order of final decree, where an observation was made by the Honorable Family Court as to the Commissioner as to make survey and furnish report with regard to the A schedule property, that is the my lord, execution schedule property is concerned. Since the present execution schedule property is one of the property involved in the said suit, it is necessary to stay the present petition till disposal of the suit is concerned. Now, my lord, para 7 per contra and para 8 would be the observation. My lord, that would be at page 119. On perusal of the record, it appears that the JDR number 1, based on the judgment passed by the so and so, has filed the present application seeking stay of the present execution proceedings till disposal of the FDP suit. On careful perusal of 21 Rule 29, it clearly states that any suit pending before the same court may be stayed. Therefore, the JDR number 1 seeking stay of the present execution petition on the ground pendency of FDP number 4/6 does not arise. Further, the Honorable so and so, my lord, this is the judgment, my lord, while remanding the matter by the district court to the FDP court. My lord, certain observation has been made.
There are two suits.
Please, my lord.
One is a suit for specific performance and the other is suit for partition.
Please, my lord.
So, suit for specific performance, who filed the suit for partition?
My lord, daughter of the first petitioner.
No. As I read in the suit for specific performance.
My lord, suit, my lord.
Suit for specific performance.
Please, my lord.
Defendant's daughter has filed the suit.
Yes, please, my lord. Yes, please.
Defendant's daughter has filed the
Yes,
suit.
please. Defendant's daughter filed a suit for partition. That suit.
And this property specific, what is the property in the specific performance suit is one of the properties
Yes, please,
in the
madam.
joint, in the partition.
Yes, ma'am. Yes, ma'am. In FDP was also filed, my lord, based on the partition's preliminary decree is concerned. Shares were allotted. Commissioner was, my lord, appointed. He demarcated the scheduled properties. Share was allotted, against which, please, my lord, an appeal was preferred by the respondent herein, challenging the order of FDP is concerned. That, my lord, appellate court, please, my lord, comes to the conclusion while remanding the matter to the FDP court, only in respect of the execution schedule property is concerned, please, my lord, to do certain exercise, my lord, as stated in para number 31 of the judgment. Now, FDP is still pending is concerned. FDP is still pending. Now, please, my lord, if he proceeds with the execution of the, my lord, the execution schedule property, certainly, please, my lord, the rights would be affected. Why? Because
regard to the specific performance.
Yes, please, my lord. That is the reason, please, my lord, I sought for execution, stay of the execution proceedings is concerned.
Yes, what do you say?
My submission to my lord is a collusive suit, that is a partition suit that is filed. My suit for specific performance of the year 2006. And that was decreed on 25/2/2011, almost 15 years ago.
25 to?
2011. And one of the daughters of the judgment debtor, she files, set up the suit for filing the suit for partition. That is, daughter is questioning the right of the father to say that the properties are joint family properties and therefore she has also got a share.
Where's the suit?
And that decree, their decree was passed.
No. What is suit is of which year? Partition suit?
2011.
2011.
2000.
Immediately after decree
25
of
of
the specific
2011.
performance suit. That is
So
decreed
almost
when?
at the time when the decree is to be passed, or little later than that, they filed the suit for partition. That is after long
That is
lapse
decreed.
time.
When?
That was decreed.
Date.
10/8/2012.
Date, of course, I have not noted it here. But so much so, my lord, all that they can say is The property which is agreed to be sold in my favor, where there is a decree in my favor, is not questioned. In the sense,
One more
it is
thing.
not set aside.
The defendant in your suit.
Is a father of the.
Was a party to the partition suit.
He is also
Obviously.
a party, my lord.
He is a
So
party.
this aspect was not brought to the
He has
notice of
got
the
a
court.
share. No. The partition suit was filed subsequently.
Correct. This decree was not brought to the notice of the court. Because this property is also part of the suit
Yes,
schedule
the
property in a
suit for
partition suit.
It's a subject matter, a portion of it, not a whole of it. All that they could do is that the specific performance decree, whatever property is there, that could be allotted to the father so that I'll get the decree executed. That is all the case. But they're dragging on the case almost for 15 years for nothing. Therefore, now at this stage, after lapse of 15 years, they are seeking for stay of the execution.
So what is the extent of your property?
My
That
lord,
is
about 5 guntas.
5 guntas. And in the partition suit,
Yes.
what is allotted to your vendor?
1/5 share also.
It would come to?
Because 5 parties. 5 persons, 1/5.
That's what, how much extent it would come to your vendor?
Not particularly in my case. I mean, there are a number of properties, not only my property involved in this.
You are also not party to that suit.
Yes,
In
I
partition
was a
suit.
party. That is Mr. B.T. Rajan Narayan. I was a party.
So there was a finding by the court that whatever falls to the share of the fifth, his vendor, that will ensure to his.
There was no specific. It
No
was
such
an
order.
ex parte decree, my lord. He did not contest. Notice was served upon him. He did not choose to file written statement. And the suit was decreed as to the prayer of the plaintiff is concerned.
No, it is like two conflicting judgments.
My lord, what the judgment, my lord, he was a party to the original suit is concerned. He did not contest by filing a written statement is concerned, please, my lord. Ultimately, the suit got decreed, granting 1/5 share to the plaintiff side.
No, as on the day, even before the trial court also.
Please.
There is already a judgment and decree in favor of one of the defendants.
But that was being set aside.
By whom?
My lord, kindly see the decree, please, my lord. That would be at page 34.
The decree in his favor is set aside.
Yes, please, my lord. The compromise dated so and so in OS so and so is held to be null and void so far as the share of the plaintiff is concerned.
Share, that is correct. To the extent of
Undivided share, my lord. Undivided share.
Then what about the remaining share?
My lord, the remaining, please, my lord, it will come it will be allotted to the, my lord, the other defendants is concerned.
That's what he is entitled for execution.
My lord, he is seeking, please, my lord, the dispute is, please, my lord, he is seeking, please, my lord, on the roadside. Even, please, my lord, in a partition suit, he will be having only undivided share is concerned. That is what, please, my lord, the FDP court and the RA court has made an observation. He'll be having only undivided share and he cannot seek for a specific share is concerned. What his vendors get, he steps into the shoes of his vendors is concerned. That is what, please, my lord, kindly come to, my lord, the FDP.
Entire extent of land in respect of which an agreement is where the specific performance suit is decreed. The entire property is part of it or only part of the property is?
My lord, entire 32 gundas is being part of it.
No, this is 5 guntas.
My lord, this is in respect of east to west, my lord, 40 feet and north to south, my lord, it comes to 5 guntas of land is concerned. Only a portion, please, my lord, what he is referring to. Towards the, my lord, the roadside is concerned. That is what being, my lord, in fact, in the appellate court also, please, my lord, there were certain negotiations between the plaintiff petitioners herein and the respondents, which, my lord, did not, my lord, turn fruitful is concerned. Now he wants a specific share is.
No, in respect of the partition suit, FDP is pending. In respect of us, now the execution proceedings are pending.
Please, please.
Yes, now, can one be independently executed? Can one decree be executed independently? Because that property being a joint family property.
Suit for specific performance was decreed on the compromise petition filed by the parties. My lord finds that on page 12.
Yes.
of 42. This is in Kannada, irrespective of that. My lord finds 23 Rule 3 provision in the top. And the subject matter, my lord finds it on page 3 of that compromise. ಕುಣಿಗಲ್ ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಸೊ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 68/2 32 ಗುಂಟೆ ಜಮೀನು ಬಾಪ್ತು BM ರಸ್ತೆಯ ಅಗಲೀಕರಣದ ಜಾಗ ಹೊರತುಪಡಿಸಿ ಪೂರ್ವ ಪಶ್ಚಿಮ 40 ಅಡಿಗಳು ಅಗಲ, ಉತ್ತರ ದಕ್ಷಿಣ 50 ಗುಂಟೆ ಉಳ ಜಮೀನಿಗೆ ಚೆಕ್ಕು ಬಂದಿ. So this is the subject matter in my suit where I sought for specific performance. The suit, that is specific performance decree as such, is not challenged by the decree, the judgment debtor. On the other hand, he sets up his daughter to file a suit for partition.
No,
When-
as far as this decree is concerned, compromise decree, it has attained finality.
Second,
It has attained finality.
yes, it has reached its finality.
You are saying that it has been set aside as far as.
Well, kindly see, my lord, the daughters, my lord, they file a suit. Kindly see the
No,
decree.
let's don't mix up both.
Please.
As far as the specific performance suit is concerned.
Lord, kindly peruse the decree. The said compromise decree was challenged in an original suit.
Let's see that.
My lord, kindly peruse the plaint, my lord, at page 24. And the prayer would be at page 28. My lord, prayer C. Page 28, prayer C, last, my lord. Consequently, declare the compromise petition dated so and so in OS is null and void.
Mm.
Now kindly see the decree, please, my lord.
Where is it?
Of course,
My lord, page 34.
the pages which are supplied to me are not legible at all of them.
My apologies.
Give him.
My lord, page 34.
No, you should have the benefit of looking at it.
My lord, I'll furnish him a better copy, my lord.
Day after tomorrow,
No, not day after, my lord, Thursday or Friday.
Thursday.
Please,
This
interim
is
order to
matter
continue.
Thursday. The interim order earlier granted is extended. Council shall furnish the legible copies of the petition to the council for the respondent. Yes.
Number 23, V. Ravi Prakash.
For the petitioner. IA number 1 of 25 is filed by me. It is not for direction. It is a sought for amendment, my lord, here. Only a spelling mistake is there. The respondent name is Ranganna. It has been mentioned as Rajanna. That's correction I wanted to make.
If IA number 1 of 25 is filed, IA number 1 of 25 is filed seeking correction of the name of the respondent.
Respondent.
Which is the correction of the name of the respondent. There is a spelling mistake. The IA number 1 is 1 of 25 is orbit, and the petitioner shall carry out the necessary amendment. Yes. Next.
The respondent here in Mallards has filed the suit for specific performance. In the said suit, the defendants were placed ex parte. Suit came to be decreed, Mallards. As against that, they have filed the execution petition, and we filed the miscellaneous petition.
When was the decree?
Suit came to suit OS number 62 of 2019. It is decreed on 16/4/2022.
16/4/2022.
4/2022. They filed the execution petition, Mallards, on execution petition number 48 of 2023 on 29/2023. And we filed the miscellaneous petition, Mallards, that is miscellaneous number 12 of 2023 on 4/12/2023.
4/12/2023.
2023. Mallards, in the miscellaneous petition also they are contesting the matter, Mallards. In the meantime, in the execution petition, an order came to be passed for appointment of court commissioner to execute the sale deed. So we advanced the matter in the miscellaneous petition, pressing IA number 1, IA number 2, the application which is filed for stay of the judgment and decree. Mallards, they for the advance application they filed the objections, but in the meantime the court did not entertain our application and posted the matter for taking steps. And these are since the matter since they have already approached they have obtained the order for obtaining the sale deed. I approached the Samba court for direction to disposal of IA number 1 at the earliest, to consider IA number 1 and dispose of at the earliest.
Your Lordship, kindly see the trial court has granted the 1 year time for appearance of the defendant before the trial court in the suit, my lord. So far, she has,
No, that is part of miscellaneous petition, which will be decided by the trial court.
yes, please.
So what we'll say is, we'll ask the trial court to dispose of the matter within a period of so and so. Till such time, don't proceed further. Once the judgment and once the miscellaneous petition is allowed, it's a different aspect. If it is dismissed, they'll avail the remedy available to them instead of keeping it pending here. The petitioner before this court is the defendant in the suit. Petitioner is agreed with a the grievance of the petitioner is that when the petitioner defendant is set by ex parte and an ex parte judgment and decree is passed, when the plaintiff in the suit has filed the execution proceedings, petitioner has filed a miscellaneous petition to set aside the ex parte judgment and decree. But the court, without consider, and also filed an IA seeking stay of execution proceedings. But the court, without considering IA number 2,
IA number 2.
IA number 2 has posted the matter in the month of
Posted the matter for taking steps, my lords.
taking steps. It is submitted that if the orders are passed by the executive court directing the petitioner to execute the sale deed, then the miscellaneous petition that itself will become infructuous, which made the petitioner defendant, sole defendant,
No, my lords. So there
No,
are
sole defendant.
petitioner,
defendants are all 6 persons. My lords. Defendants are almost 6 persons.
the
Plaintiff
petitioner,
is only 1 person.
petitioner defendants are before this court. The on on 17/9/2025, on 28/8/2025, a coordinate bench of this court had granted stay of all further proceedings
In execution proceedings. my lords.
in the execution proceedings. The same is extended from time to time. Now the respondent plaintiff has filed the respondent plaintiff or the decree holder has filed the vacate petition. When counsel appearing for the petitioner defendant submits that, if the court hears the miscellaneous petition and pass appropriate orders, the petitioner can avail the remedy available to him in accordance with law. The court, without hearing the same, has adjourned the matter for taking steps. It is submitted that they have a fair chances of success in the miscellaneous petition. Hence, till such time, there may be there shall be this court may grant stay of all further proceedings in the execution petition in the execution proceedings. When counsel appearing for the respondent plaintiff submits that, in spite of giving a reasonable opportunity to the defendant has failed to appear before the court. Having no other go, the defendant was set ex parte and a judgment and decree was passed. It is submitted that there are no bona fides in the in the case of the defendant, and now the execution proceedings cannot be stalled. Expire. Having got the counsels on either side, produce a material on record. It is an undisputed fact that a judgment, an ex parte judgment and decree is passed, and the petitioner before this court has filed an application, filed a miscellaneous petition to set aside the ex parte judgment and decree, which is pending consideration before the court. In these circumstances, at this juncture, if the execution proceedings or the proceedings before the executing court are proceeded, and if any order is passed, it would cause a lot of hardship and prejudice to the petitioner. In these circumstances, and the land counsel appearing for the respondent has argued on the merits of the matter, whether he is entitled, whether entitled for an order where the ex parte judgment can be set aside or not will be decided by the court in the miscellaneous petition, and those aspects cannot be gone into by this court. In that view of the matter, this court deems it appropriate to stay further proceedings till the miscellaneous petition filed by the petitioner is decided. Accordingly, this court is passing the following order. Which court is this?
The senior civil judge and JMFC at Malavalli.
Where your miscellaneous is pending.
Please.
The senior civil judge. Where do you get that, please?
My lords, Annexure K, page number 52, my lords.
52. The senior civil judge and JMFC Malavalli shall decide miscellaneous 12 of 2023 within a period of 2 months from the date of receipt of the copy of the order, number 1. Number 2, till the miscellaneous is decided by the court, the execution proceedings, the court shall not go ahead with the executing court shall not go ahead with the execution proceedings in execution case number, what is that?
48 of 2023.
Where do you get that?
My lords, at Annexure B, page number 27, my lords. And the order sheet is at Annexure F.
Shall not go ahead with execution case number 48 of 2023. Accordingly disposed of. It is made clear that the court shall not grant unnecessary adjournments and shall fix to the schedule, and the parties shall also cooperate. If the parties are not cooperating, still the court shall go ahead and in a time-bound manner shall decide the miscellaneous petition.
24, Rupesha B, PC Vinita.
Appear for petitioner, my lord.
Yes.
I appear for respondent number 3 and 6, Your Lordship.
This honorable court on 19 January 2026, my lord. After hearing the my lord, the contesting respondent granted stay, my lord.
What happened to the notice to R12?
Madam, R12, my lord, the Shara is there, my lord, he has left the address. I will, my lord, take out my paper publication, I will take out.
No, he is not represented before the trial court.
Yeah, he was represented and he has filed objection
Then
before
why
the
don't
trial
you
court.
take out hand summons on the council?
My lord, we have already taken hand summons, my lord, they have refused. The council has.
They refused.
Yes, my lord. Therefore, my lord, take
Saying
out paper
what?
publication. I will take out paper publication, my lord, or otherwise,
No, it
my
is.
lord, or
So
otherwise, my
hand
lord,
summons to the party itself.
I will take out hand summons to party and advocate.
Council, the petition shall take out hand summons on R12 and file a memo to that effect by 16th of June. List this matter on 16th. Interim order earlier granted is extended till then.
Lordship, one submission, Your Lordship. Only in a connected suit, which is a part of this miscellaneous petition, Your Lordship, there is a direction from this Honorable Court Coordinate Bench that to dispose of the suit within 1 year from the date of that order. That is where I filed this application for vacating the interim order, Your Lordship. And
No,
in fact,
to dispose of this matter, the notice to that respondent is necessary. That's why I'm giving on that date. On that day, we'll dispose it off.
Please.
If on by the date the memo is not filed, the stay granted by this court stands vacated.
Cell number 25.
Here for the petitioner in this matter.
Respondent.
This is I'll just give you lordships. Of course, an application has been filed by them. I'll just give you lordships a background of
Modification of what?
a stay order granted by this honorable court. Of my lord, it's a very strange scenario. They filed a suit. They filed an application for an injunction. We filed an ex parte injunction was granted. Then we filed an application to vacate. The court not heard the injunction application and the vacation application together and dismissed their application for injunction, against which not an appeal was filed by them. The lower appellate court stays the dismissal. It can't be. Therefore, we filed a writ petition saying, how do you stay a dismissal? Then, my lord, this honorable court stayed it. Today, my lord, they filed an application to modify that. In my humble submission, please see the order, my lord.
To us, we'll hear it.
Main matter itself can be taken up.
We can hear the main matter
Yes.
itself.
No, the lower appellate court's appeal is still pending.
That's one
The
more
appeal
reason
is
that
pending. They go and argue it there, my lord. There's nothing else.
The grievance is this. They have not produced the plaint.
Produce the
The plaint they have not produced. They have developed about 22 acres of land into about more than 200
Bring
villas.
copy, no?
I have purchased one villa.
No, we'll do one thing.
But
The matter is pending before the appellate
No.
court. No, let
Yes,
the
yes,
appellate
I-
court
certainly,
in a
certainly.
time-bound manner decide.
Yes, certainly,
it.
certainly. The
Decide
reason
it.
is this. In the meanwhile, contrary to the provisions of the RERA, they want to hand over the entire project to the owners association. Once it is handed over under section 11(4) of the act, the responsibility ceases. My entire grievance is they have not completed the project. They have not provided the infrastructure. They want to hand over the entire project to the owners association and get rid of the. There are three phases. The fee amount collected in phase 1 is not utilized for that. They are utilizing the amount for the phase 2 and 3. This is my allegation.
No, maybe. the
Therefore,
order of-
till then, let them not hand over the project to the owners association. We'll argue the matter of the appeal. We'll argue the matter within a day or two. Absolutely no problem. Till then, let them not hand over the project to the owners association and get rid of the responsibility. That's my entire grievance.
Owners association is before this court.
No.
But not.
Oh, one owner out of 212 owners comes to the court and please,
Association is before
please see the
court.
relief in the plaint.
No,
my lord.
he is the developer. I
No,
am the
that is
purchaser.
true. You are
No,
seeking
it's
a
yet to be
relief.
formed. That is the main grievance. They want to form the association. They try.
No.
Yes,
Once they have to form. If they form the association, then the question of you're handing over that to the association.
no,
will
there is a
arise.
statutory provision under section 11(4). The moment association is formed, it is handed over. The responsibility ceases.
No, once it is formed, you have to implement them as a party.
No, association will be. We will be part of the association. All the owners will be part of the association. My grievance is I will be part of the association, no doubt about it. But once it is handed over, the project is handed over to the association, the owners association under the RERA Act, their responsibility to complete the project comes to an end. They have not completed the project. My grievance is there are two things. If it's a structural damage, they have to complete within a period of 2-3 years. But if
But there are disputes between the owners.
no, there are no dispute regarding the owner. The dispute is only between the purchaser and the developer. My contention as a purchaser is without completing the entire project, they are handing over the project to the owners association. Once it is handed over, the responsibility ceases. This is my problem. So
What
let
was the
them.
injunction you were seeking?
Pardon?
What was the injunction you were seeking before? the
Injunction is that without completing the necessary infrastructure to the project, let them not hand over the project. Even if they form the association, that's a different thing.
Then
the
why the court has vacated that?
Yes,
Dismissed that
no,
injunction?
it's a funny thing. My grievance was that the entire project under the RERA has to be completed. The trial court says that so far as my apartment is, it is already completed. Kindly see the order of the trial court. This is the fundamental mistake committed by the trial court at page number 159.
No, if my learned friend is arguing the appeal, I'll point out your lordship because it is practically like arguing the appeal. I'm on an interim order.
Lordship asked a fundamental question. What is the grievance of the plaintiff? Why the matter should not be
please
sent
see the
back? I have
plaint.
absolutely no problem.
Please see the plaint plot from
But I have absolutely no problem in sending the matter back.
1 minute.
Kindly see at page
No,
159.
1 minute.
I'm
Where-
sorry.
Where is the IA?
Can I
IA
request, IA will see. Lordship, may kindly see the plaint. I just handed over the plaint. Code of plaint copy code. Please see the relief that is asked for in this suit. Page 10, last page, my lord. And of course, I don't know how this injunction is asked for, but anyway, my lord, lordship may see the
Grant
injunction.
a mandatory injunction.
Directing the
directing
respondent to
defendant
appropriate-
All maintenance charges already collected from the plaintiff from October.
22.
What is the
till-
prayer?
This is a sprayer.
But I understand. Kindly, kindly see that I understand.
No, under which?
Sometimes,
no,
Milord,
under which act this
Milord, I
will come?
understand. The urgency of the parties, Milord, will lead to some sort of a artificial intelligence hallucination. Kindly see my grievance at page 9, paragraph 9. Kindly see paragraph 9. Paragraph 9 of the
No, we
plaint.
understand.
Suit is fine.
But I completely understand my grievance. Kindly see my grievance. I have paid about 2 crore They have not completed the project.
Oh, but you have to
You have to
go
go to the RERA.
full-
Kindly see my application
He
before
has
that.
got the
But the
jurisdiction.
application was correctly drafted. Application which is in aid of the main
See,
prayer.
what is the prayer you are seeking from the court?
Prayer is, you have no right to collect the amount without
no.
completing the project.
What is, there should be a suit, you're seeking declaration. you're
Kindly see,
seeking
I laid the
injunction.
foundation at paragraph 9. Only 1 second. I draw your lordship's attention to paragraph 9.
Can't assume and presume what you want.
No, paragraph 9, I have laid the
The
foundation.
party has to be specific, what is the relief he is seeking?
Yes, kindly see paragraph 9. Paragraph 9.
How it is numbered in the first place?
I don't know, my lord. The suit itself is not maintainable on the face of it.
The Millard, my grievance
The
was,
kind of,
my grievance
a
was,
prayer in a writ petition.
my grievance was, they,
Beg your pardon, my lord?
No, in a 226 writ petition,
Yes, ma'am.
some kind of a relief against official respondent, that's how it is. That's how it is formulated. Granting, not injunction.
I know, as if it's a
to-
writ petition, it is
To pay
drafted.
maintenance during so and so, as if it is a 226 writ petition.
Drafted as if it is a writ petition.
Oh, I'm sorry. It's like, my lord, in Guardian Ward's case or maintenance is also.
Not kindly see
No,
paragraph.
that can't
Not,
be
I
the
will
basis
not-
of your plaint.
Not,
Your plaint
Ultimately,
to the prayer is the
ultimately,
basis on which we file a
ultimately,
defense.
not, I agree with my friend left, right and center,
Having
absolutely.
agreed with that, you
Then you
can't say
can't proceed further.
No, no, we will go before the appellate court, let the appeal be decided on the interlocutory stage, not, that is not an issue. What they want to do is, they want to wriggle out of the responsibility by handing over the project to the owners association under section, kindly see section 11(4), for 1 minute, kindly see section 11(4) of the act.
If it's RERA, there's a separate provision
No,
and there's a
that's-
bar to civil courts under
No, I will-
RERA
I-
Act.
Not, I will read and,
He didn't approach under RERA.
He didn't approach under RERA.
no,
He
RERA,
comes,
no, no,
you
this
go
will
to
not apply.
RERA if there's
No,
a
no,
problem.
No, no, RERA has no jurisdiction because it deals with the substantial alterations. Kindly see section 11(4) of the act. Once the association is formed and the work is handed over, the project is handed over, the responsibility comes to an end.
Correct, that's what
Therefore,
it
they
says.
want,
Section
what they have done
79.
is, they have not completed the project. What they have done
Have
is,
not completed.
yes,
No, under the RERA Act, what are the reliefs you have?
my relief is only regarding the structural damage to the entire project. Within a period of 3 years, they have to
Any
complete.
of the complaints against?
No, I have,
There are a
as of
number of
now, I
complaints.
cannot go before the RERA because that for a period of 3 years, the responsibility continues. If there is a structural damage to the building, etc., I can go before the RERA. Now, what they're trying to do is form the association and get out of the project. That is the problem now.
No, you are assuming something. You
No,
are assuming
as on
something.
today, the project is not complete. That's the whole problem
That's what
now.
I'm saying. You are assuming that, no, they'll be handing over the project to
They
the.
want to form the association today. 6 o'clock meeting is called. Meeting is called to form the association. I will be forced to be party of that because I own the villa. Once the association is formed, their role is, they come
How
straight.
many,
There are 200 and, what they have
212.
done,
how many units?
very very ingenious.
228 units. No one has a complaint. One person has a complaint.
Very ingeniously, what they have done is, they have not done in a entire lot. Phase 1, phase 2 and phase 3. So there is an agreement, the agreement provides for formation of the association for phase 1, phase 2 and phase 3. This is the problem. They have not completed the project as on today. Let them form the association with retaining the responsibility to complete the project. I will point out what are the responsibilities.
No,
First
not
of
your
all,
prayer
you
in the
have to-
suit.
You have to convince the court that you have a right, the suit as it is filed, and the relief as it is sought, you are entitled, and the court has not granted you. If
Foundation I
that
have
is the
laid.
case, if I am convinced,
I'm
I
not-
will
I fully-
definitely say,
Foundation without a
let
prayer.
that there be a direction and all of you go before the appellate court and let the appellate court adjudicate the matter in a time-bound manner. But now looking at the prayer of yours, I'm not inclined to grant any
Now,
prayer.
I understand. What is before the appellate court is an order passed on an application. The application succinct.
Probably the trial court must have understood what is the order it has passed.
No.
and later it has-
No. Kindly see, my lord, page 159. Kindly see page 159. This is what the trial court says.
What
So
I'll
for-
say is I'll direct the court to decide, because if it is, how can this suit be numbered?
Kindly see the application. All your lordships are aware. All interlocutory orders are in aid of the main prayer. The
Where is
main
the
prayer
main
may
prayer?
not be
Main
happily
prayer.
drafted.
I'm asking about the main prayer, not the inter prayer.
But I have laid the foundation in paragraphs 9 to 11. That's what I wanted to.
Without
put
a
your
main
lordships'
prayer.
kind notice.
No, my learned friend knows, but with his experience in civil law, my learned friend shouldn't be saying this.
No,
That
this
without a
flat-
prayer, you can say lay a foundation.
But I will not be humbled by the flattery.
No,
But
but then the
problem
point is, why?
Can
No, the best course would be, Mr. Counsel, without inviting any kind of observations from this court. Just go before the appellate court and fight out your, or if at all you have you can have any.
Well,
relief
we will
from
do
the
that.
court.
I
But
was only
I can't grant that such an order.
that in the meanwhile, formation of the association, they may have a fundamental right.
You see, when you seek a declaration without a consequential relief, the suit is not maintainable.
Let them,
Like that, in the same
let them give,
manner, without.
at least my learned friend is very gracious enough to say so many things. Let them make a statement that till the appeal is decided within a period of 1 week, they will not hand over the responsibility to the association.
that's not even-
Now kindly see, this is the problem. This is
That
the
is
problem.
not even your main prayer, sir. How do you?
Understand, you have a problem. Every problem cannot be decided before any forum. It has, you have to go before an appropriate forum with the appropriate relief.
Once
So I think going before the civil court with this kind of relief is not the
but
remedy
the
for your
interlocutory
client.
application was properly drafted and
Not go like, we can
but
take up
my
some other
only
matter.
problem is if the association is
The-
formed, they will walk out.
Then senior counsel appearing for the petitioner submits, the present writ petition is filed. Agreed by the order passed by the appellate court. Where is the order?
Page 26, my lord.
In MA number 70 of 2026, whereby
The appellate court, my lord, has stayed a dismissal.
the court has, the appellate court has allowed the MA and
No, allowed an application in the MA.
allowed the IA number 1 in MA number 70 of 2026 and stayed the operation of the order. The learned senior counsel appearing on behalf of the defendant submits that originally an order of, what is the order originally?
Order of injunction was granted.
Injunction restraining you
Restraining me from forming an association was granted.
and originally an IA was ordered whereby
Party
the
order.
defendants were restrained from forming an association. Later, the said order is vacated and the application itself is dismissed.
Dismissed, application is dismissed.
Application itself is dismissed. Against that, the respondents herein have preferred an MA. It is submitted that there cannot be an order of the appellate court or not to have passed an order staying the operation of a dismissal order. It is submitted that when the petitions have come before this court, a coordinate bench of this court by order dated 21/5/2026, an ad interim order as prayed for is granted till the next date of hearing. The respondents have filed now the respondents have filed the vacate petition. It is submitted that when the IA itself is dismissed, the said order that is passed by the appellate court is not sustainable and the order has to be set aside and the writ petition may be allowed. Then counsel appearing for the respondent submits that the petitioners, without even completing the construction, they are forming an association, and once it is handed over to the association, then they are discharged from all the, what is that you said?
Responsibilities to complete the project.
Yes.
The
discharged
responsibility
from the
shifted to the owners
responsibility.
association.
The entire responsibility is shifted to the owners and owners, and it is not permissible. Hence, on this ground, the petitioner has, the respondents have approached the trial court and filed the suit. The trial court initially has rightly appreciated and granted the injunction. Later, without any basis, the IA itself is dismissed and the petitioner and the respondents are made to file MA number 70 of 2026. In that, the appellate court had rightly passed an order in the IA seeking stay. It is submitted that if the order passed by the court, if the stay order is not continued, and once they form the association, it would cause a lot of prejudice to the respondents, and it is submitted that the balance of convenience is in favor of the respondent. I'll not record with regard to the maintainability of the suit and
Yes,
all.
yes, I let them argue it.
Having heard the counsels on either side, there's the material on record. As rightly argued by the learned senior counsel appearing for the petitioner, when once IA itself is dismissed, there cannot be any stay of the operation of the said IA. The learned counsel for this court is at the same time. This court is also not able to appreciate the submission of the learned counsel for the respondent that the order shall be continued shall be continued and there shall be a direction to the appellate court to decide the matter. In these circumstances, considering the fact that the IA is dismissed, this court is not inclined to pass is not inclined to grant any protection to the plaintiff defendant, as the same can be decided by the appellate court in the pending MA number 70 of 2026. Accordingly, the order impugned dated so and so, passed in I number 1 in MA number 70 of 2026 by so and so is set aside, and the matter is remanded back to the court, and the court shall consider the MA itself can be disposed of. MA number 70 of 2026 shall be disposed of within a period of
Anytime, whatever your lordship fix.
Within what, 10 days we are ready.
Judges.
within a period of 2 months.
One sentence,
Within a period of 2 months from the date of receipt of the copy of the order.
one sentence I may, that the formation will be subject to result of the appeal.
No.
Of course, it goes without saying. But oblige.
Yes, next.
Cell number 26.
For the petitioner, my lord.
Yes.
For respondent.
Two suits, both are for recovery of money filed before the commercial court. I am the defendant before the commercial court. I have challenged the jurisdiction of the court, territorial jurisdiction. The entire cause of action arose in Jaipur. The defendant also.
That application is dismissed.
I have not filed any application. In my written statement, the principal contention that I have taken is that one of the contentions which I took is that the court does not have jurisdiction. Issue has been framed whether the court has jurisdiction. That issue was treated as a preliminary issue and it has been disposed without an application being filed. But in any case, I am aggrieved by the order. Therefore, I have filed this writ petition. The facts of the case are that
I mean, the facts and everything are one and the same in both the cases.
in both cases, identical.
Come to the order. Page number?
Page number 16, the order starts. The operative portion is from page 19 onwards. Your lordship may kindly take para 10, page number 21.
Yes.
There are few mistakes which the trial court has done. Para 10, my lord. Further, though none of the parties has specifically mentioned in the pleadings about the place of business of the plaintiff, but on perusal of bill of supply cum invoices referred by the plaintiff indicates consignor's name and address, Vitogen so and so in Bangalore, for having dispatched the goods from the office of the plaintiff at Bangalore to Jaipur. This is factually incorrect because their own documents will show that they did not dispatch it from Bangalore. They dispatched it from Uttarakhand, Raipur, Uttarakhand to Jaipur. Nothing happened in Bangalore. Para 11. As could be seen from the perusal of para 11 of the plaintiff has also mentioned the cause of action to file the suit arose on 2/3/23 when the defendant raised purchase order and the plaintiff issued invoices to the defendant for having supplied goods from Bangalore to Jaipur in the month of April 23, and thereafter correspondence made in month of August and September 23. This is also factually incorrect because para 11 of the plaintiff does not mention anything.
Yes.
Para 12. It is held in the case of National Insurance Company referred by the counsel for the defendant that there should be special contract accepted by the consignor.
So on the fact that it is dispatched from Bangalore to Jaipur, part of cause of action has arose in Bangalore, court held that it has got jurisdiction.
Yes.
Please.
And also the other reason given by the court is that
Para
the
number 14.
invoices which they have given along with the consignment, in the invoice there is a small sentence at the bottom which says that Bangalore court has jurisdiction. Now this invoice was never agreed upon. It is not a binding contract. They supplied the material. Along with the material there is a covering invoice, and in that invoice this sentence is there. It was never agreed upon. I have rejected the goods for whatever reason. They have also accepted the rejection of the goods. Now, they have also given me a credit note for having rejected the goods, absolving me of my payments.
What was the evidence adduced?
My lord,
What was the evidence adduced by parties in this regard?
they have given me an email wherein they acknowledge
What is the evidence adduced by both the parties in this regard?
no,
In
no
some-
evidence has been.
That's it's a question of fact and law. How can it be decided like this?
If an issue has been framed, I should at least be given an opportunity to lead evidence.
That's what
Now, without, it has been treated as a preliminary issue and we have been orally heard.
this issue, it can't be decided like that.
Yes, my lord.
You have to lead evidence along with the other issues. This has to be decided.
And I did not file an application. I took a contention in my written statement. When issue has been framed, I should be permitted to lead evidence.
What do you say?
Let them lead evidence, madam. I'm not.
Set aside this order. We'll set aside this order and remand the matter back to the court. Let both of you adduce evidence, and in the course of the in the due course, it will decide.
Let the trial commence, madam. I have no issues.
There is one problem with the trial commencing. This entire cause of action, their own statements in the plaint is that they have admittedly issued a credit. Well,
all these
I will only
contentions-
take.
all these contentions which you're putting forth. The court should, all the material evidence, once you adduce the evidence, documents are marked, then the court will have, you will also have the advantage.
Let the witness enter the witness box, madam.
Just like that on a stray sentences like this, it can't be
My
decided.
only grievance is that I have been made to come down to Bangalore for to a court where it does not have prima facie, it does not have jurisdiction.
But that is your case. It is his case. Ultimately, court has to decide, and you have to come. And if it is a vexatious litigation on his part, you ask for damages for all this, or whatever costs you want. I'll set aside this order. Let it be decided with other issues at the trial commence.
Altogether, madam. Let the trial be commenced. And there could
Can
be
there be a common order in both?
Common order in both.
Please, madam. And there could be a time frame fixed, madam,
For what?
for completing the trial at least, madam.
We don't know how in the commercial courts, what is the pendency and how they are
Madam,
doing
the
it.
commercial courts, actually, they're very fast, madam.
Hmm.
To be honest before the court.
Within like 6 months?
Please, madam.
It can be done.
Any binding, my lord, because what happens every time adjournments from the defendant.
Let them complete their evidence first
We
within
will
the
do
time
it.
frame. Because I have to come down from Jaipur every single hearing date. Now, if I am being taxed to that, some lenience could be given for me to let in evidence.
6
They
months,
themselves have not started their evidence.
It is not the
In
stage.
your also 6
And in any
months.
case, my lord friend also fairly submits that commercial courts by their very nature are quite fast. So a separate order may, if I leave it to your lordship, but your lordship would kindly.
That is the
grant
only
that
request
I
I
have to come
have.
down from Jaipur. I have to leave my business and come down to Jaipur for every hearing date when the trial commences.
I'll say expeditiously.
Please.
The agreed by the orders passed in. You have a synopsis or anything so that give the next file also for the numbers.
Both are identical. The plaintiff is
3-1-3-2.
identical in both.
Agreed by the WP 1522 of 2026 is? Which order is this? Page number? You can tell the page number, I'll dictate.
Page number 16, my lord.
Agreed with the order passed in IA number on a preliminary issue number 2 in commercial in Com OS 176 of 2024 dated 3rd January 2026 and on preliminary issue number 2 in Com OS 178 of 2024 date 3rd January 2026. The defendant is before this court. Their number, they are WP number 1522 of 2026 and WP 3132 of 2026 respectively. The respondent herein, who is the plaintiff in the suit, has filed the suit for recovery of money. It is a case of the plaintiff that the plaintiff is a certified company carrying out of the business of research, which manufactures and markets a large number of animal healthcare and nutrition products for poultry aquaculture, swine, equine, and companion animals. And by plaintiff and defendants have been in cordial relationship with all their business activities since February 2023. As per the purchase order issued by the defendant, plaintiff has made supplies to defendant's company. But after gaining trust and confidence with defendant's company, the orders were received and supplies were made to defendants with the telephone conversation and WhatsApp messages. The plaintiff and the defendant had several transactions between Q3 2023 to 24/4/2023 for various products that are manufactured and supplied by plaintiff company. Upon repeated requests from the plaintiff, when the defendant company has failed to make the payments, the plaintiff has served a notice dated 3/8/2023, calling upon the defendant to clear the outstanding amount of rupees. How much is that? 96 lakhs, 832.
96 lakhs, 1,832.
832 paise. For which the defendant has not taken any steps. Hence, the plaintiff was constrained to issue a debit note to defendant. And no legal notice was sent on 22/8/2023. And the defendant and the plaintiff had filed the suit. In the written statement, the defendant has taken the ground that no part of the cause of action arose in the territorial jurisdiction of the commercial court at Bangalore. The material was sent from where to where?
Raipur in Uttarakhand to Jaipur.
Raipur, Uttarakhand.
May I submit? That is not there is no explanation. It's a vague line in the written
There
statement.
is a
Written statement is page number 30, Annexure C, para number 2. There is no description that they have not disputed.
page number 30.
Annexure C, my lord.
No, I am looking at
31.
That is
31, yes.
31, Annexures C.
That is
I
a
stated
written
that-
statement, my lord. Para number 2. There's only one line which says that no cause of action arose. Delivery of material made at
the case of the defendant's place of business is in Jaipur, Rajasthan. The delivery of the materials made at Jaipur, Rajasthan. No cause of action arose within the jurisdiction of the court. Nowhere he takes about Raipur and all.
nothing.
Their own document.
Nothing.
Their own document.
That is written statement. This
No,
is
anyway,
what.
I'm not going to decide all that.
My
Yeah.
only submission is there's no additional statement made. There's no strong objection on the jurisdiction.
Is what did you write before this? It is the case of the defendant has filed the written statement. So the court has framed basing on the stand taken by the defendant in the written statement. The court has framed an issue whether the court has got the territorial jurisdiction to entertain the present suit. And by order impugned, the court has held that the material is sent from Bangalore to Jaipur. As part of the cause of action arose in Bangalore, the courts at Bangalore have got jurisdiction and accordingly dismissed both the applications, both the
No application.
accordingly, the issue was held in favor of the plaintiff in both the suits. Next part, learned counsel appearing for the defendant submits that the findings of the court are contrary to the facts. It is submitted that the material is sent from Raipur to Jaipur. That's Raipur in Uttarakhand. To Jaipur, but not from Bangalore. it is submitted that the findings of the court are factually incorrect. And basing on that, the court had held the said issue in favor of the plaintiff. It is submitted that the order cannot be sustained and the same is liable to be set aside. When counsel appearing for the plaintiff submits that the submission of the land counsel for the petitioner with regard to the material sent from Raipur, Uttarakhand to Jaipur is without any basis. Even in his written statement also, he has not taken such a plea. The court, considering the fact that the petitioner, the plaintiff is situated in, company is situated in Bangalore, and as a part of cause of action and arose in Bangalore, had rightly dismissed, has rightly held the issue with regard to jurisdiction in favor of the plaintiff and held that the suit is maintainable at Bangalore. It is submitted that no interference is called for with the well-considered order passed by the court. Next part. Having heard the counsels on either side, there is a material on record. The plaintiff has filed the suit saying that the part of cause of action arose at Bangalore. This court has perused the written statement filed by the petitioner herein. In the written statement, it is stated that they are situated in Jaipur and no cause of action arose at Bangalore. As rightly submitted by the land counsel for the respondent. In the pleadings, there is no mention about the Raipur in Uttarakhand. The petitioner, defendant, may be having material to substantiate, may be having evidence to substantiate his case. As this issue is framed as a preliminary issue, the parties have not adduced any evidence. And this particular issue, as in these facts and circumstances, is a mixed question of fact and law. Unless and until the evidence is adduced by both the parties, it cannot be decided by the court. It cannot be decided by the court. In that view of the matter, this court is not able to, the reasoning that is given by the court and the light of the arguments that are submitted before this court cannot be sustained. And this court deems it appropriate to set aside this order and remand back the matter so that the court would be considered this, court shall consider this issue along with the other issues. Accordingly, this court is passing the following order. The order passed on issue with regard to the jurisdiction in form, so both the numbers dated so and so is set aside and the matter is remanded back to the trial back to the court. Number 2, the court shall decide this issue after necessary evidence is adduced by the parties along with the other issues. Number 3, the court shall decide the same as expeditiously as possible. Accordingly, the writ petition is allowed.
Cell number 27.
Yes.
The annexure A, your lordship, may kindly see at page 19 is under challenge. The petitioner herein is the defendant number 4 in a partition suit filed by the respondents number 1 and 3. The suit was decreed. When the FDP was pending, the defendant number 4, who is none other than the petitioner before lordship, has filed an application. One property which was the joint family property left over. It has to be included. That application was allowed, and the defendant, that application was allowed, agreed with the said order. The respondents 1 to 3 herein have approached this honorable court. This honorable court has dismissed the writ petition, holding that whatever the order passed by the learned civil judge is appropriate and proper, and proceed with the matter. Thereafter, your lordship may kindly see, the petitioner herein has presented an application to partition the property, which was the item number 7, was included in the suit schedule, as they are also entitled for the share in the property, as the father of the petitioner as well as the father of the plaintiffs are the brother. When they were in joint family, the property was granted in the name of the plaintiffs. Therefore, it is also joint family. It is the case. Then your lordship may kindly see, straight away the learned judges recorded the evidence of the plaintiff without framing issues. All purpose, when the matter was freshly included in the suit schedule, for all purpose issues have to be framed so far as the dispute concerned. The learned judges not framed any issues with regard to that. Only on the basis of the IF file, without even taking the return statement, passed an order, and thereby, since the petitioners have not led evidence, rejected the application filed by the petition. Your lordship may kindly see the suit schedule property is included in the schedule.
Tomorrow I'll take up this matter. Have a meeting tomorrow.
Tomorrow the matter is pending for commission, consider the commissioner report.
No, tomorrow on the top of the list. That is in along with the fresh matters, this matter.
Cell number 28, 29 urgent. Cell number 30.
Let this continue tomorrow's list.
Tomorrow.
Milords,
Cell number
30, I appear for petitioner, some urgency, Milords. Matter is listed tomorrow before the executing court. Milords, I am challenging the order at Annexure A.
I have no time now.
Milords, there is some.
Tomorrow it will come.
Milord, order has been passed for executing the decree. Milord, there is an
Morning
MF
10:30 they will execute it. Court will have the call work. By the time it will reach.
Sir.
Yes.
31.
morning hours, Milords, if possible.
Petitioner.
Huh?
If it is possible in the list 1, Milords.
Yes, list 1. List
Yes.
30 in list 1. Yes.
Cell number 31.
Milords, petitioner, tomorrow.
31, 32,
32.
tomorrow 33,
33.
tomorrow 30.
My lord, 33 for the petitioner, my lord. It's just that the written statement 120 days is expiring tomorrow, my lord. Hence the urgency. Can it be taken up top on list or can it be fixed for tomorrow?
33 in the first list. Yes.
Obliged.
Tomorrow. Which one? 34 tomorrow. Yes, tomorrow. Tomorrow.
List number 1.
Why?
Because urgent attachment mobiles.
How? Why it is urgent?
Attachment mobiles have been ordered, my lord.
Huh?
Attachment mobiles has been ordered.
When was the order passed?
One is on 2/5. Second, I moved before the vacation court didn't reach.
This also in the first list. Yes.
Obliged.
Cell number 35.
Lord, 35, if I may request list 1, my lord, it had reached during the vacation, my lord said listed it today. There is some urgency, my lord, it was twice it has come up before the vacation and the matter is
Oh,
not
correct.
reached.
What is urgency? What
The
time?
urgency is there is an order,
Today we sat late. that's
I
why it
understand,
didn't.
my
Otherwise
lord.
it would have.
List 1, if it may be taken up, my
Now
lord.
what will happen now that the sanctity of list 1 will go if I start posting all the
But
matters.
twice it has come up before the vacation and did not reach, my lord. That's-
Tomorrow it will reach.
Please.
Doesn't reach for you, I'll sit till
My
end of
lord.
the list, I'll take up this matter.
I don't want to,
Yes.
Cell number 36.
please.
Number 36, my lord. I request on 4th or 5th, my lord.
No, what you do is, all this KEB matters, it has to be a separate list. Don't mix it with CPC. We can't take up. So all KEB matters, separate list. No, not tomorrow. This 36 and all KEB matters next week, you say. Just
My
don't
lord,
give.
serial number 39, my lord, it is interim
No, I
order.
have not gone till 39. Please wait. 36, 37, this KEB matters. 38 is also adjourned. Yes, 39.
39, I have sought for interim prayer to appoint a PWD engineer.
1 minute. This 26 matters, let it be tomorrow. Tomorrow. Then when the final
It
hearing comes-
this matter is ordered to be listed for preliminary hearing, my lord, but I don't
That's
know.
what, preliminary, let it be listed for preliminary hearing tomorrow.
39, my lord.
40 also will be listed for preliminary hearing. Then this all fine.
Tomorrow, my lord.
No, final hearing matters, all these matters adjourn, we'll give a date for this. And just adjourn it, all matters I'll take it up from the old matters. 40? Wherever interim orders are there, extend. Yes, 44.
Serial number 40, not the date may be fixed. Not that.
Huh?
Serial number 40, that the date may be fixed.
We'll fix the date.
Because of the urgency, it was that there is an
14?
outbreak. Serial number 40.
40. It is coming tomorrow, 40.
44, my lord.
What is this matter?
Party result, what is for orders, my lord.
My lord.
Several times.
What is this?
My lord, the petition.
Flats, my lord, that petitioners have no. local
Let it
content
be
to file.
tomorrow in the list.
Tomorrow.
44 be, tomorrow.
My lords, serial number 44, my lords. The petitioners has approached the bank for the settlement, my lord. But the bank is not ready to settle the matter.
No, it's fine. You
We'll-
only adjourned it. If they're not settling, we'll dismiss your writ petition.
Please, my lord.
Tomorrow.
My lord, serial number 39, my lord.
Serial number?
39.
Yes.
In that matter, we have filed the wakalat today, my lord. My name may be shown in the cause list.
You file the wakalat, it will come anyway. It's not going to come tomorrow. 13 is going to come tomorrow.
Yes, madam. It is listed for preliminary hearing.
Then print whatever name she's saying, no? Just look at. After this, you come once about the list. Along with them, you come to the chamber.
ಮೇಡಮ್ ಅದು ನಾಳೆ ಬರುತ್ತಲ್ಲ 39.
ನಾಳೆಗೆ ಸರ್ ಅವ್ರ ನೇಮ್ ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಕಾ ಬರ್ಕೊಡಿ
ಮೇಡಮ್ 33 ಲಿಸ್ಟ್ 1 ಒಪ್ಕೊಂಡ್ರು ಮೇಡಮ್.
ಒಂದು ನಿಮಿಷ.
ಸೀರಿಯಲ್ ನಂಬರ್ 33.
ಫೈನಲ್ ಇಯರ್